the common judgment, my lord. One is engaged in extraordinary, and item number two, myself and Chaudhary both are engaged. For Chaudhary has filed an advance mention no duties, partial difficulty.
It's taken all continuously.
So without him, it cannot be hard. Maybe listed after 20 minutes, my lord.
When?
After it first week of April.
After first week of April.
April. 8 of April will be convenient. According to
8th of April. Item 1 and 2. On a prayer made on behalf of the appellants. The matters are adjourned to be listed on 8/4.
Okay. Made please last time. Thank for listing of my lord. Criminal appeal for admission. New filing, my lord. Thursday, my lord. Replay.
I just came to 13 partner.
Please, my lord. My lord, yesterday I have argued the matter extensively, but I want to clear two things for your lordship.
Yes.
My lord, yesterday, my lord, what I was arguing was that the entire conviction, which has been passed by the learned trial court, was on the basis of a confession statement and leading to discovery. Basically, that was it, and which has been argued by the prosecution. So my argument was that you cannot, the confession statement which I have given, though subsequently retracted, the confession statement was exculpatory in nature. Firstly, no witnesses, that is the eyewitnesses and the victims, they have identified me in the dock. Nothing incriminating has been recovered from me, not even any items. Now, what I was arguing is that confession statement of a co-accused cannot be used against me in light of the Kurmi's judgment and subsequent our own High Court judgment of the Bogato. The lordship put the query that kindly look at section 30 and 114B. But if we look into the evidence of the judgment of Kurmis, which I have given your lordship, the Honorable Apex Court has very well read into it, saying that 114B, the exception that you cannot read the evidence against the co-accused. Illustration. It comes with because of 133. That is approver. Because approver is a very weak piece of evidence because he has been granted pardon. And confession won't be taken as an evidence because section 3 defines what is evidence. That is, one has to be ordered in the dock and subject to cross-examination. But in the case of 164, that is not. And let me kindly look into Kurmi's judgment once. I will just
Yes.
I will take the lordship's kind attention to para 11. I'm reading, my lord.
Yes.
The question about the part which a confession made by a co-accused person can play in a criminal trial has to be determined in the light of the provisions of section 30 of the Act. Section 30 provides that when more persons than one are being tried jointly for the same offense, and a confession made by one of such person affecting himself and some other of such person is proved, the court may take into consideration such confession as against such other person as well as against the person who makes such confession. The basis on which this provision is found is that if a person make a confession implicating himself, that may suggest that the maker of the confession is speaking the truth. Normally, if a statement made by an accused person is found to be voluntary and it amounts to a confession, in the sense that it implicates the maker, it is not likely that the maker would implicate himself untruly. And so Section 30 provides that such a confession may be taken into consideration even against the co-accused who is being tried along with the maker of the confession. There is no doubt that a confession made voluntarily by an accused person can be used against the maker of the confession. Though as a matter of prudence, criminal courts generally require such corroboration to the said confession, particularly if it has been retracted, with that aspect of the problem. Now, my lord, as far as your lordship will appreciate this fact that when I was the confession statement which they have relied against me, first thing, question number 4, if I recollect your lordship, the period and where I was in custody. He says a date which depicts from the records prima facie that the accused was not aware or knowledge is there that whether he was in police custody or in judicial custody. And the learned trial or learned magistrate did not try to ascertain that fact. Secondly is that the statement as a whole, if you read, he has said that there was a dispute between Budul Mia, Jamaluddin and the deceased with respect to the bamboo business. And third was that he gave 2,600 to get some dresses. And there is nothing of the other thing which implicates him that yes, I was a part to the conspiracy. Now, if we read the judgment further, my lord, however, we are not concerned in the present appeal. When Section 30 provides that a confession of a co-accused may be taken into consideration, what exactly is the scope and effect of such taking into consideration is precisely the problem which has been raised in the present appeal. It is clear that a confession mentioned in Section 30 is not evidence under Section 3 of the Act. Section 3 defines evidence as meaning and including all statements which the court permits or requires to be made before it by witness in relation to matter of fact under inquiry. Such statements are called oral evidence. All documents produced for the inspection of the court, such documents are called documented evidence. Now, my lord, kindly come to para 13. As we have already indicated, this question has been considered on several occasions by judicial decision, and it has been consistently held that a confession cannot be treated as evidence, which is substantive evidence against the co-accused person. In dealing with a criminal case, where the prosecution relies upon the confession of one accused person against another accused person, the proper approach to adopt is to consider the other evidence against such an accused person. And if the said evidence appears to be satisfactory and the court is inclined to hold that the said evidence may sustain the charge framed against the said accused person, the court turns into confession with a view to assure itself that the conclusion which it is inclined to draw from the other evidence is right. As was observed by Sir Lawrence Jenkins in Empire versus Lalit Mohan Chakbarti, a confession can only be used to lend assurance to other evidence against the co-accused. My lord, now coming down at para 14. My lord is there. In appreciating the full effect of the provision contained in Section 30, it may be useful to refer to the position of the evidence given by accomplice under Section 133 of the Act. Section 133 provides that an accomplice shall be a competent witness against an accused person, and that a conviction is not illegal merely because it proceeds upon the uncorroborated testimony of accomplice. Top. Illustration B to Section 114 of the Act brings out the legal position that accomplice is unworthy of credit unless he is corroborated in material particulars. Reading these two provisions together, it follows that though an accomplice is a competent witness, prudence requires that his evidence should not be acted upon unless it is materially corroborated, and that is the effect of judicial decisions dealing with this point. The point of significance is that when the court deals with the evidence of an accomplice, the court may treat the said evidence as substantive evidence and inquire whether it is materially corroborated or not. The testimony of the accomplice is evidence under Section 3 of the Act and has to be dealt with as such. It is no doubt evidence of a tainted character and as such is very weak. But nevertheless, it is evidence and may be acted upon subject to the requirement which has now become virtually a part of the law, that is, that it is corroborated in material particular. So, my lord, as far as the illustration which your lordship yesterday pointed out, so why I am trying to draw this lordship's kind attention is that in our case, there was none of the accused persons, any of the accused person who has given a confession and subsequently he was being granted pardon, because then only accomplice will come, because his evidence will be recorded under 133, whatever his statement. But he is not supposed to be cross-examined. That is kept, pardon has been granted. But here in our case is that all of them were tried together, all of them have implicated each other, all of them have given an exculpatory statement. Number 3. Number 4 is that all of them have retracted subsequently. And your lordship will appreciate the fact that yesterday, though there was nothing recovered from me, but since the disclosure statements were there, one of the disclosure statement I have produced before your lordship, draw your kind attention, and how the disclosure has to be proved. If disclosure statement goes away, it was not being proved in the doc as it is required, then the entire proceedings goes away. So these are the two things which I raised upon. Subsequently, my lord, my learned friend let my other colleague argue the matter, and I will take a liberty there if your lordship, I will clarify. But before I part away, my lord, there was one very celebrated judgment of this honorable court. It is Kutugwala versus State of Assam. Yesterday I was going to read, my lord, I could not place it yesterday. 1980 SEC Online, Guwahati, 21. It talks about the confession as a whole, my lord.
Yes. Which para?
My lord, it will be para 25, authored by Justice Lahiri, my lord. Here that question, here that aspect was, the simple issue was there, my lord. The confile giving a recording a confession, whether it is an honest or the duty is cast upon the presiding the officer who is recording the confession to putting a question to the indigent person that, are you aware of these formalities about that I am not a police officer, you won't be sent back to the custody? Plus, whether a legal aid should be provided at that point of time or not, a competent legal aid. Because normally, what the authors were there at that point of time found that normally a person having intelligence and affluent, he is not going to confess. It is the poor who doesn't know the consequences. They confess. They confess. So that point, at that point of time, it's a vital issue is that whether at that point of time a competent legal aid should be provided or not. Because to know the implication, because a wise man won't do that. So this issue was dealt, my lord. And it was held that a legal aid should be provided so that
You have not gone through the other judgments.
my lord, yes,
What
the
is the
legality
judgment?
is not required at that.
Which judgment?
My lord, there are judgments, even this issue has been read in some other matter in Supreme Court also. Supreme Court has said that is
This
not
is judgment where Justice Ansari has given a separate judgment. That has not been held to be a good law. Legal aid. It's not compulsory, not mandatory. You place all the judgments. Don't place one judgment like this. This aspect has been well settled. There is no requirement of giving a legal aid for making a confession.
my lord, I think because law always keeps on evolving. But
So whatever is settled now.
my lord,
We cannot now settle a law which is settled by the Supreme Court.
my lord,
This
I,
was raised, this was a part of the judgment, disapproved by the Honorable Supreme Division Bench of the Calcutta High Court. And this was a single opinion of one of the judges, honorable judges, not the division bench. You take out the judgment.
my lord. So this was one I wanted to highlight.
There is no such requirement of legal aid. You take out the judgment.
My lord, I will do that. I will do that. Let my colleague.
I'm appealing appeal number 245 of 2016.
Two,
Appeal number 245 of 2016. That is Jamaluddin Majumdar, Udul Mia versus
245 of 2017.
16.
16. Jamaluddin,
Jamaluddin.
one appellant.
Only one appeal.
Yes.
Last together, I have supplied the index, my lord, as director. That is available. Or
The index distributed.
the extra copy. No, it will not. In this case, initially I was not succeeded in this case, your lordship. But subsequently, by way of supplementary search sheet, I was brought in. That is, your lordship will find it, paper book number, part 1, volume 5. That is page number 1287. That is supplementary search.
Supplementary charge sheet, yes.
That is search sheet number 09 dated 24/11/2005.
25/11/2020.
It was search sheet number 09 dated 24/11/2005.
24/11.
Initial search sheet.
Initial was 25/11.
No, here it says, my lord, that top page, my lord.
Yes.
Search sheet number 1 of 2016, that is supplementary. And another search sheet was earlier in the point of time, that is
What
09.
is the date of the initial charge sheet?
That is 24/11/2005,
Not 25.
not 25.
24. Okay.
Now he says, my lord, that your lordship will start from page 1288.
Hmm.
Then Sri Anil Chandra Dev, younger brother of Prabhu Dev, lodged a written complaint at PS Katlitera on 18/3/2004, alleging that his brother Prabhu Chandra Dev, along with driver Munia Laukar and his Mohore, Muhammad Dalaluddin, left at about 9 a.m. on 73/2000, that is 7/3/2021, for Bhairavi in his commander vehicle bearing number 20. At about 11:30 to 12 a.m., some Riang extremists had taken away from Baichera. Accordingly, FIR number 19 of 24, under section 120B, 464 IPC was registered against unknown Riang extremists. Even after investigation, file circuit number 09, dated under section 120B, 464 as well as substantive offence under 364A 302 against 8 accused on 25/11/2005. Investigation against the other accused person continued with the leave of the court. The present search sheet is filed against Jamaluddin alias Gudul Mia is a continuation of earlier search sheet whose details are given in the paragraph above. Investigation conducted by CBI further revealed that deceased Pratul Dev was born and brought up in Katlichara in the state of Assam. After his education, he went abroad and served as a teacher at Ethiopia, Kenya, Nigeria for 14 years. In 1986, he went to London, settled there along with 3 daughters and wife. His family members are British citizens, whereas he continued to be Indian citizen with an Indian passport. In London, he worked as an executive officer for the British government, local service, and during January 1999, took voluntary retirement. He then returned to Assam in India, where his family remained in London. In 2001, he contested assembly election from Katlithara constituency as a BJP candidate against his own brother-in-law, Sri Gautam Roy, a Congress candidate, who won the election. Presently, Gautam Roy is a cabinet minister in the government of Assam. Sri Procedural Chandra Dev started bamboo business, was allotted 5 bamboo mahalls during the 2002-2003 by the government of Mizoram by order dated 21/10/2002. The mahalls were allotted for a total bid amount of rupees approximately 67 lakh. In the bamboo business, he was assisted by Jalaluddin Majumdar, who was working his manager, Mohori, and Munia Lahokar, who was working as a driver. Sri Patul Sahib used to go to Bhairavi in Mizoram by road in his vehicle once or twice every week and used to stay at Bhairavi along with his driver and assistant. Investigators further disclosed that Patul Sahib has stopped the bamboos of one Horimia in the month of January-February 2004. This Horimia is a bamboo worker of Budumia. It was a contention of Patul Dev the bamboo is so stopped was a local bamboo. He himself wanted to purchase it and sell it himself. However, Budumia wanted to get the bamboo released by paying royalty to Patul Dev. On this point, there was an exchange of heated arguments between Patul Dev and Budumia in presence of Khoghendra Sagma and Horimia. After departure of Patul Dev from the bamboo depot, Budumia asked Khoghendra Sagma to see him at Hormura. Thereafter, Khoghendra Sagma, along with one Sukural, visited the cloth shop of Budumia at Hormura. Accordingly, Khoghendra Sagma and Sukurali made Budulmia in his cloth shop at Hormura. Budulmia took Khoghendra Sagma separately, asked him to abduct Patul Chandra Dev. For this task, Budul proposed to pay Khoghendra Sagma rupees 1.5 lakh. After making arrangements of the persons and arms to abduct Patul Chandra Dev, Khoghendra Sagma and Ranjit Sagma, alias Fora, talked to Budulmia, who assured the boat to give 1 lakh after completion of the task of abduction. After 3-4 days of kidnapping, Khoghendra Sagma made Budulmia inform him that Patul Chandra was been killed. A few days after the abduction of Patul Chandra Dev, Budulmia paid Khoghendra rupees 10,000, later 5,000, instead of 1 lakh. Later, after a few days, when Khoghendra Sagma went to Budulmia in his shop at Khormura to collect the remaining amount, some heated arguments and altercation took place between Budulmia and Khoghendra over payment of money. But no amount was paid by Budulmia. An argument was sorted out by the intervention of Nizamuddin Majumdar. Investigators conducted revealed that deceased Patul Chandra Dev was abducted till pursuant to a criminal conspiracy. Immediately in the aftermath of the quarrel which has taken place at Choranga between Patul Dev and accused Budulmia, Budulmia had initially offered 1.5 lakh to Khoghendra Sagma for abduction of Patul Chandra Dev. Accused Khoghendra Sagma then planned the abduction with the help of Kalijoy, Kalpunu, Sahadev Sagma, Master, alias Master, Sahadev Sagna, alias Gruba, and Krishna Mahadev Sagna, Pinachans, Ranjit Sagma, alias Kora Sagma, Rupdam Sagma, and Nandu Sagma, who were part of the criminal conspiracy. Hence, Budulmia is also liable to prosecute under Section 364A, 302, 120B, as Patul Dev has been kidnapped and killed at the instance of the accused Budulmia. This supplementary charge sheet against him has been filed in continuation of earlier charge sheet filed on 25/11/2005. So, you'll also find
That is why I said earlier it says 25/11.
yes, by 25.
You are saying 24.
No, 25.
That is why we have written 25.
Yes. I wrongly typed my report. Maybe typing mistake.
It should be 25, I think.
Yes. Now you'll also find that they have in this search itself they have named one Sukur Ali, my lord. They say that your page 1289, middle portion, Khoghendra Sagma along with Sukur Ali visited the clothes shop. According to Khoghendra Sagma and Sukur Ali made with in the clothes shop, Budulmia took Khoghendra separately, asked him to so and so. So Sukur Ali has been made a witness in this case and he was declared hostile.
Sukurali.
Sukur Ali.
Number 29 or what?
Number 29, yes. And there's another witness is Akbar Ali, my lord. He was also declared hostile.
Akbar is to 15.
PW 15, my lord. And there is another evidence of PW 14, my lord. He was also declared hostile.
Sarif.
Salif. Now, the charges I'm coming to your lordship, their charges have been amended subsequently, my lord. That is, your lordship will find in volume number 1, part 1.
What are the materials against you?
Materials, these are the actually, these are the persons.
These two, 14, 15 and 29 have been declared as hostile
Hostile.
by the prosecution.
Prosecution.
They were cross-examined by the prosecution.
Question.
Now, what are the materials which have evolved?
So, no, for cross-examination, they have denied that they made any statement implicating me before the police. So,
And what was the police statement
police statement is that
regarding contradiction?
that contradiction they have proved it, but court has disbelieved them. Trial court has disbelieved it.
Disbelieve these witnesses?
Yes, ma'am. Now only remains the confession statement. But in the confession statement, subsequently they have retracted the confession in 330. When it was put to them that one
Confession made by whom?
one by this is Khagendra Chakma and Ranjit Chakma.
Khagendra is Mr. Borago, his client.
Yes, ma'am.
Khagendra and Ranjit is another one.
Another one. And the exhibit 63 and 60.
How many confessions are there?
8 confession, but these 2 has implicated. Others I have not.
Khagendra and?
Khagendra and Ranjit Chakma. And Ranjit did not prepare an appeal. And Khagendra Chakma, my lord, if you take it, your lordship take his 331 statement, my lord.
They have, Khagendra and Ranjit have implicated Jalaluddin.
Jalaluddin, yes.
Jalal or Jamal?
His name is Jamaluddin.
Jamaluddin.
Jamal. Alias Gudul Miya.
These confessions have been retracted
Retracted.
in 313.
313. And one has stated that he was being assaulted also. The Ranjit Mail. Your lordship, I am coming to it, my lord. That part. Khagendra page part 2, volume 1, my lord. No, your lordship, 313 statement, your lordship will come. Part 1, volume 1, my lord.
313 is
Of Ranjit Chakma, my lord.
Ranjit.
Page 479, 480.
479, yes. Well, at 167, last time we have noted, 167 is the confessional statement of Khagendra,
Yes, my lord.
correct?
Yes, my lord.
Part 1, volume 1.
Volume 1.
And 173 is the confessional statement of Ranjit,
Ranjit Chakma.
which is at 179.
Yes, my
He is accused number 8.
lord. 8.
And Khagendra is accused number
Khagendra is accused number 7.
7. And at page 479, which is part 1, volume 2, the retraction is there.
Yes, section is there, and they have given an explanation.
479 is Ranjit.
Ranjit, 479 is Ranjit Chakma, my lord.
What are these questions 370 to 375?
The questions were put, my lord. Actually, that was
370 to 375.
yes. PW Wine stated that on 25/5/10, Chief Judicial Magistrate had ordered it to entrusted him to record the confidential statement of Khagendra Chakma and Ranjit Chakma. Then he taken plea that we are severely beaten by CBI. I do not remember what statement I have made. Then he said that
Ranjit says he was beaten.
yes, ma'am. Then he says that again he was put that on 26/10/2009 accused Khagendra Chakma and Ranjit Chakma were produced before him on 10, and both of them gave their free and voluntary confessional statement before him. Confessed you along with him other accused persons. In his case, entered into conspiracy to abduct deceased Procedural Chandra Dev for ransom, abducted the deceased, and after receiving ransom of rupees 5 lakhs, kill him as well as the deceased suddenly. I'm not aware of it. I have forgotten this.
The magistrate has been examined.
Magistrate examiner PW 9. He has exhibited.
What does he say?
He says CBI has stated that they would take us to a Sahab.
What are the dates of the confession?
Dates of confession, I'm coming to it. Already at it.
And when was this PW9 examined? 2 dates.
PW 9 has been examined. I'm coming to it again. On 1/6. It says there on page 116 of volume 1.
Hmm.
Thereafter, on being endorsed by then Chief Judicial Magistrate, Amarjit Day, by his order dated 25/10/2005, marked as exhibit 6, accused Congress.
No, you give us 2 dates. When was this magistrate examined?
A
As a
magistrate
ma-
was examined.
examined, and when was the confessional statement recorded?
Magistrate was examined on 14th of March 2008.
14 March 2008.
Yes.
PW9 was examined.
Yes, magistrate was examined.
Okay, and when was the confession recorded?
Confession was recorded on, that is what, 26/10/2005.
26?
10/2005.
So this evidence was rendered after about 2.5 years.
Yes. It was 2008, it was 2.5.
Which is the page of the magistrate's deposition?
The preposition is, it starts from page 111 and relevant page is 116,
Volume 1.
volume 1, part 1.
I did not find any injury in the person of both the
Voted.
116.
He says that but now, though he states, my lord, both the accused persons, both the accused were recorded in afternoon, one after another, after complying all the requirements of filling up the form of recording confession. Whether both were present at the time of confession, that was not there, my lord. But one after another, it was recorded.
No, you have given a wrong date, Mr. I see the first line. On 10/9/2005, I was working as additional chief. On that date, Krishna, Madhav and Sahadev.
We are not Sahadev, my lord.
No, understood.
Yeah.
Krishna, Madhav and Sahadev were examined on 10/9.
10/9.
And this Krishna, Madhav and Sahadev has not given any statement against
Yes,
you.
we know.
Or this Khogendra and
Khoghendra
Ranjit have-
and Ranjit.
So when were they examined?
That 116, my lord.
Page 116.
lord. 25/10, they were produced, my
116 where?
lord. Top.
Oh, yes. Enter therefore. 25/10, right.
And their statements were recorded.
25/10.
They were sent to
No,
judicial.
25/10/2005.
5.
You said confession 26/10. Okay, 26/10.
26, they were sent to judicial custody, my lord.
Okay. Next day they were.
There.
You're correct. We are concerned with Khogendra.
Ogendro
And
as well
Ranjit.
Ranjit.
I did not find any injury.
One point, it's number 1.2 down with your occupant. I asked the accused if there was a torture, ill treatment by the police on it denied. 1.2 down.
It's like
No, this is not in connection with these two persons. This is in connection with Krishna and Sahadev. Is there a similar line for Khogandra and Ranjit? It starts at 116, correct?
yes.
One point, torture. 1.6.
Yeah, that we have already
Yes.
read out. I did not find any injury. Both did not complain about any torture.
Yes.
The confession, we have to examine two parts, the voluntariness and the truthfulness. Even if the magistrate is also exempted under 80, he need not come to the witness box. Somebody else could have even proved this, because that document is given some kind of a sanctity.
Right.
Because it is recorded by the magistrate, but nonetheless, magistrate has come. So whatever he says, whether it's true or false, the magistrate cannot say. Magistrate can only say that I had followed the procedure. So we have to look into the truthfulness and voluntariness. Voluntariness part magistrate's evidence more or less can cover. Truthfulness is one part which we have to really examine. Unless it's truthful and voluntary, confession perhaps should not be relied upon. Okay.
Fullness, so one say that if it is inculpated, fullness can be put. This is
No,
the
truthfulness can be examined if we look into the other materials. What are the other witnesses? Is it corroborating? Is there a match or is there a mismatch? Is he trying to wriggle out of the situation, or is he trying to put the blame upon somebody else or him? Is it exculpatory, which Borgo has argued, or whether it's inculpatory, putting him in the blame upon him? So if it's trying to wriggle out of the situation by putting the blame on others, it will be an exculpatory confession, which may not be very safe to rely upon. Yes.
Yes. Now, if your lordship takes up down, question is that, my lord, come up with your lordship. Even if you take that, this confession is true and false, because they are not substantive. As your lordship pointed out in judgment, my lord, by Justice Jatendra Gatkar, my
Yes.
that is very clear, my lord. The
But if it is corroborated,
That-
if you harmoniously construct
yes, my
30 and illustration B2114.
that is applicable in case of approval.
No. If first is read 30 first,
Yes, my lord,
read 30. Read 30.
because in case of approval, he is a
Let us read 30. Thirty is not restricted to approver. 30 is a very general principle of law.
general principle
laid
of law.
down.
But that has been clarified in that judgment.
Haricharan Kurmi has said, how do you reconcile the illustration B to 114?
Yes.
Reading both together, the safe method is to have corroboration. You just cannot, one says it is though under 30, it's admissible. 114 illustration B says unworthy of any credence.
Yes.
So how do you reconcile? Please read 30 again.
30 minutes.
Oh. Of the Evidence Act.
Yes, I am coming. 30 says, my lord. Also, consideration of proof confession affecting a person making it and other jointly under trial
Under
of
trial for same
Same
offense.
offense.
It's not an approver.
approval.
Trial under same offense.
Yes.
Where
Where
more
more persons than one are being tried jointly for the same offense, and a confession made by one such person affecting himself and some other such person is proved, the court may take into consideration such confession against such other person as well as against the other person who make such confession.
Hmm.
So,
And you see the explanation.
offense used in this section includes abatement, attempt to commit an
It
offense.
is so broad.
Yes, I understand.
Even then see, read the illustration.
Illustration A and B jointly tried for murder of C. It is proved that A said B and I murdered C. Court may consider the effect of this conspiracy against
Yes.
B. Then A on his trial for murder of C. There is evidence shows C was murdered by A and B. He said A and I, C murdered C. This statement will not be taken into consideration by court against A as B is not jointly tried.
Yes, see.
Yes.
Now here's a case of joint.
I understand, my lord.
But still then, your safeguard is at 114B.
Yes, ma'am.
Come to 114B. This has to be read with 114B, illustration B to 114.
114B, my lord.
Yes.
That the accomplice is unworthy of
credit,
credit,
unless it's
corroborated by immaterial particular.
So what is requirement? What is the requirement is being corroborated by material particulars. Simply a confession made by one accused,
yes,
tried jointly, will not rope in the other accused unless it is corroborated by material particulars.
Material particular. But in this state, those corroborating evidence are lacking.
Yes, that you have to argue.
That corroborating evidence is lacking because those were declared hostile. And court also, my lord, in their finding, my lord, and did not rely upon them. So lordship take the judgment also. Court did not rely upon. I'm coming to the judgment part. It's volume 1, part 5. Relevant page, paragraph 35, my page number 1217. You also may come to page 1215, my start from there.
Yes.
They have discussed the prosecutor witness number 14, Sai Volilostar, page 1215. He has stated, I do not repeat anything, that this witness was declared hostile on the prayer of prosecution, therefore he confirmed his statement purport to be his. According to 161 CRP, suggestion has been made prosecution. He stated CBI, that so and both the accused numbers so total have become angry and that later revoked so. However, prosecutor did not confirm the same. That is important.
You are reading paragraph?
Paragraph 32, my.
Yes.
Page, now, if you also come page 1216, my lord. The first paragraph, last 2 lines. However, the prosecution did not confirm the same from the investigating officer who was examined by the prosecution witness number 5. There was suggestion made by the prosecution to the prosecution witness number 14 cannot said to be attend evidentiary bail. So after confrontation, that has to be proved by the IO that he has made success. That has not been done by their fault. So that suggestions do not have any evidentiary bail. That is the finding of the court. Then similarly, prosecution witness number 15, Akbar Hussain. Down below, however, he has not testified, has thus he was also declared hostile in the prior prosecution, was confronted with his statement during investigation, but same has not been confirmed by the investigating officer by the prosecution. The said suggestion put by the prosecution cannot say to be acquired any evidentiary weight. However, the testimony of prosecution witnesses, number one, to confirm that Bamboo belonging to accused, number 9, belonging to number stop in on the instruction of victim Protul. That much he has come. But he has, otherwise he has disbelieved those witnesses. Then your lordship will last, then again your lordship will come to page, paragraph 35, man.
1 to 17.
Page 1,
1 to 17.
1 to 18. Yes, 1 to 17, my lord. Start.
Mm.
That with regard to abduction of Protul Dev, along with the prosecution witness number 1, 4, 5, as well as with regard to the abduction of victim Sadanna, the confidential statement of the accused person have been found corroboration from one another. It is also be seen that prosecution witness number 1 and 4, 5 are not only eyewitness to the abduction but also victim. All the 3 persons have corroborated the confidential statement of the accused person. The prosecution witness number 4 and 15 have not stated there was a quarrel between the accused number 9 and victim Protul Dev, and the confidential statement of the accused number 7 and 8 corroborating one another in this regard to the effect that accused number 9 was the mastermind so far the abduction of Protul Chandra Dev was concerned. The confidential statement getting corroborated in all other aspects by other accused persons as well as the victim eyewitnesses lends credence to the story of the prosecution that he and accused number 7 initially conspired to abduct Protul Dev for a ransom. Thereafter, accused number 7 and his other conspiracy involved other accused persons 1, 2, 4, 5, 6, and 8, along with several others who were willing to be an active partners of the conspiracy. It is seen that confidential statements of the accused persons so far hatching of conspiracy and giving effect to same is concerned, then corroborated by testimony of prosecuted witness number 4, 1, 4, and 5, which remain unsketched. It is to be noted the fact that the bamboo belonging to accused number 9 was stopped under the instruction of Protul Dev has been corroborated by witness number 14 and 15. Learned counsel for defense argued that such minor dispute could not have rise to a conspiracy of such magnitude. It is pointed out that prosecution witness number 1 stated in examination 5 on a fateful day Protul Dev was proceeding from Katlichera to Bhairavi. He was to go to the shop of accused number 9, Dharmura. Due to shortness of time, he could not do so. However, this can be explained that victim Protul Chandra Dev did not have any ill will or grudge against accused number 9. Accused number 9 does not stand exonerated by state. So they have no relation whatsoever so far the case is concerned. Now, then it comes subsequently, finally, my lord, on the then he comes finally in paragraph 31, paragraph 38, page 120. In view of the above, it is held that confessional statements of the accused persons 1, 2, 4, 5, 6, 7, and 8 are voluntary, truthful. Those have been corroborated by the testimony of other witnesses. They can be relied on in the instant case of one for finding against the accused person. And accordingly, they have relied upon them. And thereafter, my lord, he had paragraph 64, he has dealt with me, my lord. Page 1 to 37.
64.
There are 64. Man.
One, two.
Relevant portion is 1, 2, 3, 8. Top portion, my lord, 1, 2, 3, 8. It starts from 1, 2, 3, 7. As the conference statement in this regard, made by accused number 1, 2, 3, 4, 5, 6, 7, and 8, stands sufficiently corroborated, as these conference statements have held and have been held to be voluntary and true. It is held that accused number 1 and 2 pursuant to conspiracy initially had by accused number 7 and 9. Thereafter confided other remaining accused persons, extorted the money from the family members of late Protul Chandra De. The prosecution witness number 3 has stated that callers kept making demand of ransom and threatened to kill him. He threatened him of killing his uncle in the event he did not pay the ransom. As same has been rebutted by same has not been rebutted during cross-examination. As such, point of determination of number 9 has also answered with affirmative. From the evidence on record, Eastern prosecution was successful in bringing home the allegations, both direct and circumstantial evidence, regard to conspiracy of kidnapping of late Protul Chandra De for ransom and his kidnapping, extortion of ransom amount with regard to abduction of Jalaluddin Mujumdar, Santosh Monia Lohar, and Muhammad Ator Rahman, late Saranand Nath. Of the accused number 1, 2, 3, 4, 5, and 7 have committed dacoity, having causing hurt to late Protul Chandra De in course of the same. The accused number 1, 2, 3, 4, 5, 6, 7, and 8 having common intention to kill Protul Chandra had alleged surrender and having murdered the state accused person of the state eight accused persons committed the offence under section 201 34 IPC in convincing the court of a officer being guilty, being reasonable beyond reasonable doubt, having committed the said offence. In result, accused then he stays my lord. There was no specific finding so far as how he has been implicated. In the result, accused Jamaluddin, Gurul Mia is proved beyond reasonable doubt, having committed offence under 120, 364A, also having committed substantive offence under 364A, 386, is convicted accordingly. It is noted that pursuant to conspiracy headed by him, ransom was extorted from the family member of late Protul De. And however, he is acquitted of charge under section 364, 365 IPC. There is no evidence the victim Protul De or the victim has kidnapped with intention of murder, and the accused has conspired to abduct other persons. So my submission before Lord. So what the finding is, there is no specific finding that whether he was part of the company. According to prosecution, I paid him for purpose of kidnapping. I did not told them to extort money from them. That's not a case of prosecution case that I had a personal enmity with the accused, with the victim, Protul De, regarding supply of it. And then, according to prosecution, that I requested this Ranjit Chakma and Sadev Chakma, especially Sadev Chakma, to kidnap him. Only for purpose of killing, I will pay you 1 lakh rupees. But I did not pay the full amount. Initially 10,000 and subsequently another 10,000 was. There is no evidence or there is no allegation also that I have asked them to extort money from their family. Now, the fact remains that from the judgment also, it appears that only evidence that remains is the confessional statement, the co-accused. Apart from confessional statement, there is no other evidence. So my humble submission is since there was no corroborating evidence implicating me for commission of the offence under section 302 or 364A or 386 IPC, I am entitled for it. I still rely on the judgment of this court pilot. As Baragoa has submitted that, I is not for me, but that judgment fully covers me. I did not repeat again the same. These are my stuff. And presently I am on bail, my lord. And this honorable court, my lord, finding that the findings are not perverse, my lord, and have granted me bail very fast.
I mean item number 10, Lord.
Number
Criminal appeal number 266, public
16.
16.
Name of the accused?
Sahadev Chakma, last Purapa. I mean accused number 1.
May I take a leave?
Yes, yes. Counsel, what is your name?
P. Dotcom. I'm behind the bar 19 years, 6 months, 13 days as on that.
Hmm?
I'm behind the bar as on 19 years, 6 months, 13. I'm arrested on 29/8/2005.
Yes.
Let us get it in the page number 119, volume 1, volume 5, part 1. So, yeah, okay. Volume 5, part 1. There are 9 charges against the petitioner, against the appellant. The charges are your 120B, 364, 364A, 302, 201, 386, 395, 397, and 34. 9 charges are framed against the appellant. Initially, the charge was framed under section 120B, 364, 302, and 201. Where is the evidence of the PW7, part 1, volume 1, page number 99 to 105.
Who is PW7?
Is Lakshman Malakar,
Page?
page 99. Is the witness of the disclosure statement of the appellant Sahadev Thakma.
PW7.
PW7. There are 2 Sahadev Thakma. One is Sahadev Thakma alias Puraba and Sahadev Thakma alias Master. Married
Lakshman Malakar.
Malakar.
Yes.
I am working at telephone exchange at Hailakandi. As per direction of the SDO, the Kostov Chakraborty accompanied the CB official. Ozoloto also accompanied the CB official. CB officials took me in Ozoloto to Monughat in the state of Tripura. 2 persons were also taken by CB officials. Their faces were covered with cloth. At Monughat, CB officials prepared a disclosure statement of Sahadev Thakma in presence of myself and Ozoloto. Accused Sahadev Thakma put his signature in my presence as well in the presence of Ozoloto. Exhibit 8 is the disclosure statement dated 8/9/2005 of Sahadev Thakma, a one invoice signature of Sahadev Thakma, which I recognized as it put before me. 8 is my signature. Disclosure memo statement of Sahadev Thakma was also prepared by CB officials in my presence and in presence of Azal Doctor. Exhibit 9 is the disclosure statement of Sahadev Thakma. Exhibit 9(1) is the signature of Sahadev Thakma. I recognize the signature as it was put in presence of presence. Exhibit 9(3) is my signature. On Exhibit 9, after taking the signature of Sahadev Thakma, I put my signature. Exhibit 10 is the discovery cum seizure memo which was prepared in my presence as well in the presence of Azal Doctor on 9/9/2005. By this discovery cum seizure memo, 2 pages of Bohikhata had been seized in the top of the house of Tapan Burwa. Exhibit 10(1) and 10(2) are the signatures of Sahadev Thakma. I identified the signatures as it were put before me and in presence of Azal Doctor. Exhibit 10(5) and 10(6) are my signature on Exhibit 10. Exhibit 11 eligible of 7 pages seized in my presence in presence of Azal Doctor in the stop of Tapan Burwa. Exhibit 11(3) and 11(5) are the signatures of Tapan Burwa. I identified the signatures as it put before me and Azal Doctor. Exhibit 11(9), 11(10) and exhibit are my signatures on Exhibit 11. Exhibit 15 is the disclosure statement of accused Krishna Madhav Thakma prepared in my presence and in presence of Azal Doctor on 8/9/2005. Exhibit 15(1) is the signature of Krishna Madhav Thakma put my presence. Exhibit 15 is my signature on Exhibit 15. Exhibit 16 is the production cum seizure memo dated 9/9/5 was prepared in my presence and in the presence of Azal Doctor Bhai. The seizure memo to golden links and 2 pages of Bohikhata had been seized to the shop of house of Tapan Burwa. Exhibit 16(1) is the signature of Krishna Madhav Thakma. I identified the signature as it was put in my presence and in the presence of Azal Doctor. Exhibit 16(2) and 16(3) are signatures of Tapan Burwa. I identified the signatures as it were put in my presence on Exhibit 16. Exhibit 16(5) is my signature as a witness. Exhibit 16 is the disclosure statement of accused Ruptan Thakma dated 9/9/5 was prepared in my presence
and Ozol Datta. Exhibit 16.1 is the signature of Rupton Sakma. I identified the signature as the signature put in my presence. Exhibit 17 is my signature on Exhibit 17. Exhibit 18 is the production term. Scissor memo prepared in my presence and in the presence of Ozol Datta. By this scissor list, one golden ring was placed from Rajkumar Sakma. Exhibit 18.1 is the signature of Rugdon Sakma. I identified the signatures of the same was put in presence of myself and Ozol Datta. On this scissor memo, Rajkumar Sakma put her thumb impression in presence of myself and Ozol Datta. Exhibit 18 is my signature on Exhibit 18. Exhibit 1 is the identification memo dated 7/10/2005 was prepared in my presence and in presence of Ozol Datta and Deepak Bhuiya. By this memo, I have been shown on the steel cover, steel packet which was still in Tripura on the recovery of the article. I had also been the specimen steel. I had compared the steel of the packets and impression thereon comparison. I put the packet and the steel intact. On the satisfaction of the same were opened in my presence, in presence of Ozol Datta and Deepak Bhuiya. After opening the articles was shown to the family members of PC Dev and one of his manager, namely Anil Dev, Sudeep Dev, and Jalaluddin. Articles were shown to all of them individually and separately presence of me and Deepak Bhuiya and Ozol Datta. All of them identified in the articles found in the packet individually and separately and told that some of our PC Dev who used to weigh the step. After the identification of the articles were resealed and packed, by putting wax on the packet along with the some impression and accordingly separate specimen of wax the seal impression had been taken in my presence and in presence of Deepak Bhuiya and Ozol Datta. Exhibit 117 to 120 are my signature put in the identification memo dated number 1 dated 7/10/5. I also recognize the signature of Anil Dev, Sudeep Dev, and Jalaluddin Mozumdar put in Exhibit 1. Exhibit 24 is the specimen seal of impression. The seal used for sealing an envelope white identification memo dated 7/10/5. Exhibit 24-2 is my signature put on the state specimen seal and impression. The Ozol Datta and Deepak Bhuiya were also present. Exhibit 26, 27, 28, 29, and 30 and 31. Packet used for sealing and packing the articles recovered and after identification it was resealed. Exhibit 26-3, 27-2 are my signature on the packet after sealing and resealing the identification. Exhibit 28-2 and Exhibit 29-2 are my signature put in the packet after sealing and resealing the identification of the article. Exhibit 33 and 31-2 are my signature put on the packets after sealing and resealing of the packets after identification. At the time of recovery and sealing, Sri Ozol Datta was also present along with me. At the time of resealing the packets, after identification, Sri Ozol Datta and Deepak Bhuiya were also present. They had also put their signature in those packets, cross-pattern. Due to laptop time, I do not remember the color of stone fixed over the golden ring. I don't remember exactly in which place the monoghat and the ring was recovered. One Mr. Deepak Bhuiya had also put his signature in Exhibit 30. Later on, he has stated that he does not remember who put his signature. I don't remember the color of the stone fixed in the golden ring. I don't remember the color of the stone fixed on the ring packet on Exhibit 26. Seals were pasted in my presence on Exhibit 26. Before using the seal, it was shown to me if there was any damage. I don't remember what was written over the seal. I did not accompany the investigating for recovery of all these things. This is the important one. I was present at the time of recovery of the ring. 2 of the rings were recovered from the house of Tapan Borua and 1 from Rajkumar Sakma. I will not be able to identify Rajkumar Sakma because of laptop time. I will not be able to identify Tapan Borua due to laptop time. I accompanied the investigation to the house of Rajkumar Sakma for recovery of the ring. I don't remember how the ring was recovered from the house of Rajkumar Sakma. I was standing outside the house of Tapan Borua. Later on, I was inside the house. I don't remember the size of the house of the Tapan Borua. The rings which was recovered from the house of Tapan Borua was kept hidden in a container. I don't remember whether the size and color of the box. Today, I have not seen the container of the court. It is next question. It is not a fact that I did not accompany the CBI officer. It is not a fact the rings were not recovered in my presence. It is not a fact the rings were not sealed and packed in my presence. I had put my signature on Exhibit 1 after reading the contents. Anil Dev, Sudeep Das, Jalaluddin had identified the gold rings by Exhibit 1. It was prepared at CBI camp at Hailakandi town. I cannot identify the person who had drafted the Exhibit 1. Exhibit 8 is the statement of Sahodhi Sakma. Sahodhi Sakma stated that if they get to Monu Bazar after, something will be recovered. I cannot able to identify Sahodhi Sakma as he was muffled. Exhibit 9 is the statement of Sahodhi Sakma. He has stated about some golden article, but no golden articles were recovered, but one bohikota was recovered. Exhibit 10 is the statement of the Sahodesh Takma. He has stated about the some gold articles, but no golden articles were recovered, but one bohikata was recovered. Exhibit 15 read over to me by CBI officials after I put my signature. Exhibit 16 was read over to me after I put my signature. It is related to recovery of 2 rings in the house of Tapan Borwa. Exhibit 17 is the statement of Rugdon Thakma. Rugdon Thakma stated that he sold 1 ring to Raskomai Thakma. Exhibit 17 was prepared in the house of Raskomai Thakma. I also went to the house of Raskomai Thakma with CBI officials. House of Raskomai Thakma is probably at Lalsera. Only 1 ring was recovered in the house of Raskomai Thakma. I did not enter inside the house of Raskomai Thakma. Raskomai Thakma produced the ring. CBI team as well as police entered into the house of Raskomai Thakma. Exhibit 18 was prepared and after handing over the ring by Raskomai Thakma. Exhibit 18 was read over to us after I put my signature. It is not affected. I put my signature on white paper. It is not affected. Exhibit 8, 9, 17 and 18 and Exhibit 1, 10, 11 are not prepared in my presence. It is not affected. Exhibit 1, 8, 9, 10, 11, 17 and 18 were not read over to me.
He is the independent witness which the CBI had asked to accompany.
Yes, doctor. But
Telephone person.
Yes, doctor. For recovery of the golden. In his prosecution, he has stated that the Exhibit 9 is the statement of Tohotekwa. He has stated that some gold article, but no golden articles was recovered. Yes, doctor.
So what was recovered then?
1 bohi khata was recovered. Loose paper.
No golden articles recovered.
No golden article. 104 in the cross part. About some gold article, but no gold and a gold article was recovered, but 1 bohi khata was recovered.
Bohi khata means register.
Loose paper.
Register property.
Register. One is stated upon board.
Bohi khata.
Bohi.
Okay.
May read to PW8. Raman Chandra Malakar, ACS officer, he was the inquest officer. (106). May I read?
Yes.
At present, I am working as an election officer of Dunai subdivision in the district of Dhemaji. On 4/9/2005, I was working as block development officer of Lala Development Block in the district of Hailakandi. I had also power of executive magistrate. On 4/9/2005, on being led by 2 accused, I, along with the CBI officials and 1 land record staff Mondol, 1 disaster management staff, went to village Vaisera under Katlisera PS in the district of Hailakandi. 2 doctors also accompanied us. 1 doctor was from Katlisera PHC. His name was Dr. Subrata De. I cannot remember name of the other doctor. 1 person from CFSL was also with us. In the village, in the bank of stream Nala, we found some bones, skulls, some chappals, pen, socks, T-shirt, and 1 peacemaker, money bag, and T-shirt and pen. After getting all these things, I prepared inquest report on the remains of human skull and bones. While reaching on the spot, seeing that chappals and pen, to deep identified those are belong to the deceased total death. In the inquest report, I mentioned the details of the pacemaker. Exhibit 6 is the inquest report prepared and signed by me on 4/9/2005 at the spot. Other witnesses also put their signature in my presence in the inquest report. Exhibit 6.2 is my signature on the inquest report at page number 2. After preparation of the inquest report by me, CBI officials prepared the recovery memo of the article found the spot in the same day, that is 4/9/2005, and took possession of the article. The articles which were recovered were sealed and packed in my presence and other witnesses. CBI officials took my signature on the cover of the steel packet. Exhibit 7 is the recovery memo which was prepared in my presence. Exhibit 7.2 and 7.3 are my signatures on the recovery memo. Other witnesses also put their signatures on the recovery memo in my presence. Accused also put their signatures in my presence. Exhibit 5 is the identification memo number. I was prepared in my presence in the CPI, in the camp of CPI of Hailakandi on 8/4/2005. On the particular day, other witnesses were also present. The articles packet of Vaisera was opened at the camp. At first, we were shown the sealed packet to verify whether the seals are intact. After satisfaction that seals are intact, the packets are opened in my presence and as well as in presence of the witnesses. After opening the packets, articles were shown to the brothers and nephew of the deceased, Protuldev separately in my presence. They have identified two of the articles to be of deceased Protuldev. Thereafter, the articles were again resealed in my presence and other witnesses. Exhibit 53, 54, 55, 56 and 56 are my signature put on the exhibit 5 along with other witnesses. Both the relatives of PC Dev and other witnesses also put there in my presence on exhibit 5. Exhibit, next question. Exhibit 37 is the specimen seal impression dated 815, which were taken in my presence. Exhibit 31 is my signature and exhibit 37. Exhibit 38 is the also specimen seal and signature dated 811-5, which was taken in my presence. Exhibit 38-1 is my presence. Exhibit 39 also specimen seal of impression dated 811-5 taken in my presence. 39-1 is my signature put in 39. Exhibit 40 is the identification memo dated 811-5 was prepared in my presence as well as the presence of other witnesses and two ladies being the mother and sister of Sadhana. We have been shown the seal packets and after comparing the seals and signatures and finding the seals intact, the same were opened in my presence of myself and other witnesses. After opening the packets and articles were shown to the mother and the sister of Sadhana individually and separately in my presence and in presence of other witnesses. Both of them identified three of the articles to be the Sadhana. The articles are again packed and resealed separately in my presence and other witnesses. Specimen of the cells were also used, also taken separately. Exhibit 41, 42, 42 are my signatures put on the identification memo in Exhibit 40 dated 811-5. Other witnesses also put their signature in my presence. Some impression of one lady and signature of Santibala Nath was taken in my presence. Exhibit 41 is the specimen seal and signature was taken in my presence. Exhibit 41 is my signature and exhibit 41. Exhibit 42 is the impression of seal used in the sealing and package which was prepared in my presence. Exhibit 42-1 is my signature in exhibit 42. Exhibit 43 is also a specimen seal and is my impression dated presence of sealing the articles identification memo 2 dated 811-5. Exhibit 41 is my signature. Material exhibit 61 is my signature put on the packet after resealing. Material exhibit 71 is my signature put on the packet after resealing. Material exhibit 10-1 is my signature put in the envelope after sealing. Exhibit 44 is the packet wherein I put my signature after sealing the packet. Exhibit 44 is my signature. Exhibit 45 is the packet which is still in my presence. Exhibit 45-1 is my signature put on the packet of 45. Exhibit 46 is the packet which is still in my presence. Exhibit 46 is my signature put in the packet after sealing. Exhibit 47 is the sealed packet which was sealed in my presence. Exhibit 41 is my signature put in the packet after sealing. Exhibit 48 is the packet sealed in my presence. Exhibit 41 is my signature put in the state packet in as witness. 41 is my signature put in the state packet as witness. Exhibit 49 is the packet sealed in the presence. My presence. Exhibit 49 is my signature put in the packet after sealing. Exhibit 50 is the packet sealed in my presence. Exhibit 51 is my signature put in the packet after sealing. In the cross part also, I was deputed by the district magistrate Hailakandi to accompany the CBI official. State of the order is not with me today. Yes, today, the CBI officials I had come to know that they were led by two accused. It is the important. Yes, today, by the CBI official I had to come know that we are led by two accused. The said two accused were muffled. They were not at all. They were not so tall. I did not talk with the accused person.
Okay, which part are you reading now?
What a cross part of it.
Page 109.
109 Lordship. Yes, today. May I read Lordship?
This is cross of PW 8.
8. 8 Lordship.
Yes, today.
Yes, today. By their CPA officers, I had to come. Know that we were led by two accused. For the first time, he came to know that they were led by the two accused person. The prosecution version is they were led by the accused person.
Now, this witness, he did not know. You see, 27 has to be connected with 26.
Yeah.
He is an independent witness.
Yes, sir.
Disclosure made before the police.
Yeah.
That is enough. Now he's trying to lend support to the prosecution case. That there was a disclosure statement. Now, what are you trying to?
For the first time, May 20 before Lordship, for the first time, he has come to know that they were led by the two accused. The prosecution version is that that
No, is he a CBI person?
the,
PW8?
Oh.
Huh? Who is he? He's
he's the SS official.
SS
Lord.
officer.
SS, executive. He's the inquest official. Lord.
he's not the investigating agency.
No, Lord. He's the inquest official. Lord. This is distance from the married. Lord.
The rings which are recovered, are these connected to the, anything done to connect with the deceased?
Just he's the inquest official. Lord. Skull and
The rings.
rings. No.
Re- Huh? There is evidence that rings were recovered,
Yes. Lord.
not the gold ornaments.
No, not good.
Yes, but the rings, were it connected to the deceased person?
From the prosecution version, this is the related with the deceased. Lord.
No, that we know,
Yes,
but
sir.
what is the evidence?
It is evidence of 20 upon Borwal. Lord.
Who is it?
He is the businessman lordship. As per the case of the prosecution, we have sold the items to the gold items to the Sapan Kumar Borwal. Gold articles, that is the rings, gold, chain lordship. We are sold to the Sapan Kumar Borwal.
No. Two rings have been recovered.
Yes, sir.
Now, is there any connection? Is there any material on record to connect these two rings? Because these two rings belong to the deceased.
Yes, sir.
Who has said that this? Yes, I know that these rings belong to the deceased.
Sudip Dev lordship, PW3 lordship. He has maybe he identified lordship. Sudip Dev. Identified PW3 lord.
That the rings belong to the deceased.
Yes, sir.
And this remains of the skull and bones were
Yes, sir.
scattered within a
large
distance
deep-
of 100 meters.
Yes. Married lordship. Distance from Hailakandi to Vaisera is about 60 to 70 kilometers. We left Hailakandi at down. From Hailakandi to Ramnathpur, we used to light vehicle. From Ramnathpur to Vaisera, we went on foot. It took about 5 hours to reach Vaisera from Ramnathpur. At about 1:30 to 2 p.m., we reached Vaisera, the area where remains of human being found is about 100
100
meters.
meters.
Yes, sir. Next page, sir. Some articles were found in the stream and some on the bank. After searching many places, we reached the last spot. We proceeded about 100 meters upstream in the place when we found remains of human being and found one pen and chappal. Sudip Dev, the nephew of the deceased, identified the pen and chappal to be the deceased Potol Dev. It is not a fact the inquest report and recovery memo were not prepared on the spot on 4/9/2005. The articles were shown to be me before sealing and packing, but I don't remember details of description of articles. Today I cannot say contents and the sealed packet. It is not a fact that today I deposed false evidence. Page number 57. Part 1 volume. He can identify PW tip he identified. I can identify the material exhibit
57.
57. Lord. May I read, Lord?
Sudip Dev.
Is a PW till. Is a nice of the portfolio.
Who is Sudip Dev?
He is the nice of the deceased portfolio. Lord.
Not niece, he is his nephew.
Yes, nephew. Lord. I can identify the material exhibit 1, 2, 3, 4, and 5. The golden color rings belong to Protuldev and he wear those rings. Metal exhibit 1, a golden color ring. Metal exhibit 2, and a golden color ring. Exhibit 3 were identified me. 1 to 9 in my signature put on this bill. Metal exhibit 6 is the blue color ball pen belong to Protuldev and I can identify this. Page number 58. May I read Lotu? A seal cover with a coat metal seal is opened in the coat after being satisfied with the seal in presence of both sides. This cover may contain MR number 1195 and 1200 and 1202 5. Metal exhibit 6 is the blue color ball pen belong to Protuldev and I can identify it. Metal exhibit 7 is the leather parts belong to Protuldev and I can identify it. Metal exhibit 8 is the t-shirt belong to Protuldev which I could identify at the place where it was recovered and accordingly the investigating agency seized it. Today also I can identify it. A seal cover with coat metal seal is opened in the court after being satisfied with the seal in presence of both sides. MR number 10235, 106, 1207 and 12805. Metal exhibit 9, MR number 130 is the black color full pant with the black belt and metal exhibit 12 is the pair of chappal belong to my uncle Protuldev, which I can identify. By identification memo, exhibit 5 and metal exhibit 6, metal exhibit 7 and 8, 9 and 12, along with other articles were identified by various witnesses and I can identify the 5 items stated above. Exhibit 5.2 is my signature and put on exhibit 5. Yesterday, I identified 2 accused persons in the top. There was a TIP held in the Hailakandi jail. About 50 to 60 persons were arranged in a line. The magistrate holding TIP asked me to identify the persons to whom I paid a sum of rupees 2.5 lakh near the Bodot Cinema Hall at Tilshore and another sum of rupees 2.5 lakhs near Bhoidavi Saranga. And accordingly, I identified those 2 boys whom I identified in the top. Cross partnership. Merely because of the size, I can identify metal exhibit 1 belong to Protuldev, but there is no any special mark on it. The witness volunteered. I had been seeing my uncle using this thing regularly, so I can identify the same to be of my uncle. My uncle used to shift his fingers when he used metal exhibit 2. Ring 2 like metal exhibit 2 is not made in Barak Valley. Because of the size of metal exhibit 2, I can identify to be belong to Protuldev. The witness voluntarily I had been seeing in my uncle using this ring regularly. So I can identify the same to be of my uncle. In Indian market, such type of ring can be found. Fingers like metal exhibit 3 can be found in Barak Valley. Protuldev used one white ring on his little finger and one red stone with surrounded by white small stone on his ring finger. Just after seeing the metal exhibit 3, the witness stated, "This is the white stone ring used by Protuldev, used on his little finger. I don't know whether ring like metal exhibit 4 can be found in market. I have identified metal exhibit 5 and probably Protuldev used to wear this ring on his ring finger on right hand. He used to wear 8 rings on his finger, shifting the rings of both sides. I don't know whether any other persons can make or use like metal exhibit 5. Exhibit 5. I don't know the brand of metal exhibit 6, but I can sure that is the made in England. Articles made in England can also be found in India market. I also use same type of metal exhibit 6 which was gifted to me by Protuldev. On the day of recovery, seeing this pen, I handed the same over to investigating agency. I don't know whether anybody can give such type of pen to others. On seeing metal exhibit 7, I can identify that it belongs to Protuldev. Generally, past does not bear a buckle, but metal exhibit 7 being a peculiar one which buckle I could identify. Yeah. And it belongs to Protuldev, except this peculiar buckle There is no other specific mark on Metal Exhibit 7. Total Dev used to wear t-shirts. Metal Exhibit 8 often so I could identify it. I am not aware whether this t-shirt was brought from London. Total Dev used to wear Factual t-shirts of India with a size of XL, but it is a size made in England as it is size was XL, double XL. T-shirts like Metal Exhibit 8 may be found in market. I don't know whether any other can use this type of t-shirt. Total Dev used to wear pants in England. The waist size of Metal Exhibit 9 is befitting to the waist of Total Dev. Waist size of Total Dev was about 38 or 40. Total Dev came from England few months prior to his election, and at that time he brought Metal Exhibit 2. On seeing this at the place recovery, identified the cop. I don't know whether any person can buy chappal like Metal Exhibit 12. I don't know whether the manufacturer manufactured only one pair of chappal of this size. It is not a fact I have deposed policy in respect of identified Metal Exhibit. Next page. On 17th 2004, around 7.
These disclosures were revealed when? What is the time gap?
Disclosure was still may not 3/9/2005, Doctor.
39. And
39.
the incident?
Incident 17/3/2004.
1.5
Yes.
1.5 years.
Yes. Disclosure statement, Lordship, 3/9/2005, Part 2, Volume 1, page number 233.
Campus CPF.
Here.
No, we are on the time gap.
Yes, sir.
When was and what is the discoveries made? The description of the articles vis-a-vis the time gap. One t-shirt.
Case paper. One of the
Support
total remain. Top.
Top. and support was also. Mary Lordship.
Yes, please.
60, page number 62, Lordship. On 17th 2004, at around 7 a.m., my father and uncle Anil Dev told me about the abduction of Pratul Dev. I was the first person to be informed about the abduction of my uncle Pratul Dev. On 17th on being informed about the abduction, I, along with my father and uncle Anil Dev, went to Katlesar PS. But I don't know whether FI was lost on that day. When I received a telephone call from PW1, we abandoned the idea of going to place of occurrence. So, though we had already planned, I cannot say as to where PW1 and Munialoha went soon after they released from captivity of the abductors. I did not see any injury on the persons of PW1 and Munialoha. PW1, being the manager, had known exactly about the business matters, including monetary transaction of Patul Dev. Our family members collected the money from different sources, and PW1 was present all along in such collection. I don't know whether PW himself collected any amount. I don't know the name of the employee of the Sarangia who had who, who informed about coming of Batibura Sakma on 26/4. On 23/4, I did not go along with PW1 and Munialoha to Sarangia. Patul Dev arrest the arrest came at Sarangia by taking a quarter of railway on rent where we used to stay when visiting Sarangia. I don't know if any person was arrested on the basis of ID collar which was put in our residence.
Okay,
Or
we take a break.
Yes,
like
sir.
5 minutes.
No, no. Rupees 40 lakh. Page number 63. Second page. Ransom was rupees of 40 lakh, which was gradually reduced to 30 lakh and then to rupees 10 lakh. And finally, as SP Hailakandi told us to pay rupees 5 lakh, and accordingly, deliberation being made with the abductors, and it came to down to rupees 5 lakh. On 29/4, when we went to 66. On 29/4, when we went to Silchar near the Bodh Cinema Hall to pay the first installment, two persons came and PW1 seeing them coming caught hold of their hand. The PW1 told me that those were the street boys. Two boys. The street two boys asked us to sit in a auto rickshaw, but I refused and Jalaluddin PW1 silent at that time. At that time, police were playing the were standing just 30 feet away from us who also saw me with Jalaluddin PW1 and the street two boys sitting in a auto in our vehicle. The police also knew that the said two boys came to collect money from us. After collecting money from the said
Two boys.
the said two lower left the place. All
But I did not see as to which way they.
did not say they left. The state police team did not ask us anything about, and I also don't know if they followed the state two boys. The state police team and we returned from the place due to positive or not. After 3 days, 3-4 days, I along with PW1 went to Sarenga to make payment of the second installment as stipulated by the abductors. Thereafter, again myself, PW1 and my father went to Bhoravi with the second installment on the same day around 5 to 6 p.m. I along with PW1 went to pay the second installment from Bhoravi to Sarenga. We also informed the police that two of us abductors told us on the day that if the second installment was paid, their to their soldier boss would be angry. We tried to know as to who their soldier is, but they did not disclose. I also don't know whether the police ever tried to know about their state soldiers. When the CBI people conducted investigation and recovered bones and other materials, I was all along with the CBI people. I don't know how long the CBI people were conducting investigation. The day on which the bones and other wearing apparel to recover, I was present along with the CBI people, and those were recovered within a day, but I don't know remember the date. All this were recovered within an area of 10 to 15 feet area. These materials and bones were lying overground. I was only non-official civilian on the day with the CBI team, and we were led by two persons having marks on their mouth, but I could not identify those two persons. After recovery of the bones and other materials, CBI team packed and those things in snacks and packets, and I put signature on some paper on the day itself. The recovery memo was prepared on the spot on the day, and I put my signature thereon as instructed by Mr. accompanied us on the day. I saw two boys whom I identified in the log in the other day. On 3 occasions after the incident, when I made the first and second installments of the ransom, and on the day when they were mixed up with the others in Hailakandi jail. In Hailakandi jail, when I identified the two boys, in them were with different dress with different colors. About 50 to 60% were lined up in the jail, and all the persons are of the different status, and some had beard, some had and I did not see the preparation of the recovery memo while it was prepared. It is not a fact that I don't know whether materials exhibit like coating, pants, chappal, etc. belong to Procedural, but I deposed false. It is not a fact that I falsely identified two boys. It is also not a fact that as guided by PW1, I deposed an identification on the in this court. It is not a fact that all the accused persons in the dock were the employees of Procedural or Debt, and they used to work in Bamboo's business. It is not a fact that I am forced to be a witness and is guided by investigating agency. I deposed this case.
Where is the test identification parade memo?
It was It was held on 10/1/2005.
Memo.
Memo Lordship, Part 2, Volume 1.
Part 2, Volume 1.
Page number 186.
Part 2, Volume 1. Volume 1. One 86.
186. Where did the order Lordship? TIP was conducted after 40 days of my arrest.
No, not the order, the memo prepared by the magistrate.
188. এখন আমি- চাৰিখন আছে। মেমো
20.
সেই লওক। Studio till.
Is it?
Studio till. Memorandum of TIP held at District Jail, Hailakandi on 9/10/2005 at 11 a.m. May I read, Lordship?
Yes.
We started from the court award, District Jail, Hailakandi, for conducting TIP at about 10:40 a.m. and reached there at 10:45 a.m. And I made the in-charge jail superintendent, Sri Dulal Devnath, executive magistrate, and the jailer Al Thandu, and asked them to make arrangement for holding TIP inside the jail premises. And in the meantime, witness namely Sudip Dev, Jalaluddin Mudumdar, Santosh Luhar, Nunia, and Ataur Rahman Loskor are made to sit in the office of jail, wherefrom they could not have any access to the proceeding that is going to be conducted inside the jail. Witness Sudip Dev informed me that he is going to identify only two persons who received the ransom from his hand 2 times. Once at the Silchar Devadut bus stand, and on the other occasion Bhairavi Sarenga. The reference witnesses submit before me that they are going to be identify all the 5 persons online. The suspect accused are mixed up with the UTPs, and the ratio maintained 8:1. Witness Sudip Dev was called to identify the suspect from the line, and he identified Kalapanu and Gunabam and Krishnamadav Thakma to be the persons to whom he paid the ransom amount at Silchar bus stand, Devadut, and at Bhairavi Sarenga. Thereafter, the witness also was made to go outside the jail premises, stayed away accompanied by the jail constable. Next witness, Jalaluddin, was made to the parade, and he was asked to identify the suspected and the line which were reshuffled, and the suspected were mixed. Go with the other UTP's garments, and from there he could identify all the suspects. Then the witness was made to go outside the jail premises accompanied by jail constables. Then the witness Santosh Luhar was called and asked to identify all the suspects on the line. After its reshuffling, once again after his identification of all the suspects accused, this witness was also made to go outside the jail premises along with the jail staff, and thereafter the line was again reshuffled, and the accused suspects are made to wear the garments of the other UTPs. Witness Ataunanul, of course, was called, and he was asked to identify the suspect from the line, and he is also to identify the 4 suspects except accused Sahadesh Thakma and alias
204.
Kuraba
Just a
from the
minute,
line.
just a minute. 204. No, 203 is done. 203 is. No. 204. 204 is. 204 is also there. Where is it? Yes.
Missed middle. Witness Ataur Rahman Loskor was called, and he was asked to identify the suspect person from the line, and he is able to identify 4 suspects except accused Sahadev Thakma alias Kuraba from the line. Thereafter, he was made to go out the jail premises. Then the line was dismissed. After completion of holding TIP, I returned back along with my staff to the court at 12:15 p.m. certified that this memorandum in presence in this Sunday, the 9th day of October 2005. Order was passed for conducting TIP on 7/10, 2005, and TIP was conducted on 9/10/2005. And the 4 persons were asked to identify the accused. That is the witness number PW number 3, Sudip Bid, and PW1, Jalaluddin Mozumdar, PW5 and PW4. 1, 3, 4, and 5 were asked to PW1, 3, 4, and 5 asked to identify the accused persons. The PW may submit my arrest. I was arrested on 28/9/2005. After 40 days of my arrest, the TAP was conducted, and in the meantime, I was regularly appearing before the court, and my photographs and my visuals were already, they have already known. Therefore, the TAP was not in a proper procedure. My physical appearance they have already known in various occasions during the investigation.
Yes.
My evidence page number 66, I have already continued. It is not affected all the accused person in the talk whether employees or portal and they used to work in this bamboo business. It is not affected. I am forced to be a witness, and in this guided by investigators, I depose false. Now let's see page PW 13 let's see. 13 135 141.
Page 67,
135 let's see.
135.
PW number 13 lot. Is the revenue staff of DC Deputy Commissioner of Hailakandi.
Asid Dev.
In this case, there are two Sahadev Thakma. One is Sahadev Thakma alias Masto, and one is Sahadev Thakma alias Korobal. And he stated that I don't know who is the Sahadev Thakma. Sahadev Thakma alias Masto or alias Sahadev Thakma Korobal. May I read the evidence?
Yes.
In the year 2005, I was working as a Patwari revenue staff in the office of the Circle Officer Katlisera in the district Hailakandi. I remember I became witness to the case relating to the murder of Patul Chandra Dev and Sudhanna. As directed by the Deputy Commissioner, I, along with the Nilam Prasad Yadav, went to CBI camp at Hailakandi 3/9/2005. In that case, in presence of myself and Nilam Prasad Yadav, Sahadev Thakma alias Hunba made a statement that he, along with Krishna Madhav Thakma, if taken to the spot, then he can find out the place and he can remain in the dead body. As he, along with the Krishna Madhav Thakma, with the other members, killed PC Dev and Sadhana. Exhibit 78 is the disclosure statement of accused Sahadev Thakma alias Suraba, recorded in my presence and Nilam Prasad Yadav. Exhibit 78 is my signature, put on Exhibit 78. Exhibit 78-1 is the signature of accused Sahadev Thakma alias Suraba, put my signature. Similarly, accused Krishna Madhav Thakma also made same statement before us and CBI official. He also said that if he will be taken along with the Sahadev Thakma, then he can find out the place where they had killed PC Dev and Sadhanath and get the remains of dead bodies. Exhibit 79 is the disclosure statement of accused Krishna Madhav Thakma, dated 3/9/2005. Exhibit 79-3 is my signature. Exhibit 79 on Exhibit 79. Exhibit 79-1 is the signature of Krishna Madhav Thakma, put my presence of S. Nilam Prasad Yadav and CBI official. I identified the signatures today. As disclosed by the accused person is name above, I myself, along with CBI official, doctor with Magistrate Asim Malakar and Subrata De, nephew of PC Dev, along with CRP person from labor, went to the spot led by accused Sahadev Thakma Huraba and Krishna Madhav Thakma. At first, we went to the vehicle up to Ramnathpur. Thereafter, taking a rest for about 45 minutes, we went on foot. After crossing a river, walking, entering a forest, the road was zigzag. After 2 hours walk, we reached the spot. There is a spring where we found the heads of one skull and one pacemaker, one side, one pen, toes, socks, purse, a belt, etc. After getting the remains and articles, her inquest report was prepared by Magistrate R.C. Malakar in my presence and in presence of the others who went to the spot. Exhibit 6 is the inquest report prepared by R.C. Malakar on 4/9/2005. Exhibit 6.4 is the my signature on Exhibit 6 at page number 2. At page 2, articles were packed and sealed in the spot in my presence. A recovery memo was prepared by the CBI official in my presence and all those persons named above who accompanied us to the spot. Exhibit 7 is the recovery memo dated 4/9/2005. Exhibit 11 is my signature on Exhibit 7. Exhibit 7.5 is the signature of Saudi Sakma alias Puraba. And Exhibit 7.6 is the signature of Krishnavardhan Sakma. What the accused put their signature in my presence and police who accompanied us. Exhibit 7.2 is the signature of Subrata De. He also put his signature in my presence and I identify his signature. As per direction of the DC Hailakanti, 11/9/2005, I went to the CBI camp. There CBI officials from labor, CRP personnel and 2 persons were present. CBI officials told that the persons whose faces were muffled are accused of PC Dev's murder case. At time they stated that after killing Procedural Dev, they concealed 2 rifles, uniform and viscera. At viscera, they can show place if they will be taken there. CBI officials recorded their statement. At the time of putting signature, I know their names as the Kalapano Sakma and Sahadev Sakma alias Master. Sahadev Sakma alias Master put his thumb impression in my presence. Sumandas was on labor was also present. Exhibit 82 is the statement made by the accused Sahadev Sakma alias Master and Kalapano Sakma alias Gunbam Sakma. Exhibit 82-1 is the signature of Kalapano Sakma alias Gunbam Sakma. Exhibit 82 is my signature on Exhibit 82. Exhibit 82-3 is the signature of the Sumandas who put in my presence. On this same day, the accused Kalapano Sakma and Sahadev Sakma alias Master lead us to the spot. Sumandas was who went with us. On the death of Horebi from Ramnathpur, on the side of the railway track, we went over the hill under the Simlo tree, made some round and saw the place. Then they namely Kalapano and Sahadev Sakma alias Master dug the place and recovered 2 rifles, one with a broken condition. CBI official prepared a recovery memo and sketch of the 2 rifles broken as well as the intake to also prepared sketch the place where the rifles were found. Exhibit 83 is the recovery memo of the rifle dated 4/9/2005 in 2 pages. Exhibit 83-1 is my signature and 83-2 is my signature of Sumandas who put before me. I identify the signature. 83-3 is the signature of Kalapanu Sakma who put his signature in my presence and Sumandas. Sahadev Sakma alias Master put his thumb impression in my presence and other person. The rifles were separately packed and sealed at the spot. Metallic seal impression which were put on the seal pack, who put in the recovery memo in my presence. 83-4, 5, 6, and 7 are the specimen seal impression put in the recovery memo. 84 is the rough sketch map of the broken pieces of the rifles recovered. 84-1 is my signature, and 84-2 is the signature Sumandas put in my presence. I identified the signature. 85 is the rough sketch map of the rifle. 85-1 is my signature. 85-2.
How is the rifle connected?
It was collected.
Now, how is it connected? Connected with the offense?
It is connected with the offense that they show their gun when they adopted the
At the
photos on
time
the.
of adapting,
Yeah,
two 2 gunmen had come.
Yes. 86 is the rough site map of the place where from the rifles were recovered. 86-1 is the signature. 86-2 is the signature Sumandas who put it in my presence identified signature. On the same day, on 11/9/2005, Sahadev Sakma alias Master had also disclosed in my presence and he along with the Kalishan Sakma had concealed the 1 rifle, 1 pistol and 3 military uniform in the forest of Haisera near the house of the youngest sister of Hogendra Sakma after kidnapping and murdering of PC Dev and Sadarnath. He can show the place if he will be taken there. Exhibit 80 is the disclosure statement of Sahadev Sakma alias Master. Exhibit 81, 82 is the signature of the disclosure of Exhibit 80, 82 is the signature of Sumandas. The statement was made in my presence and in presence of CBI officials. Sahadev Sakma alias Master put his thumb impression in Exhibit 80. Thereafter, accused led us to the spot near the house of the younger sister of Hogendra Sakma at Bhaishara Forest. He showed a place, but we could not recover any article. He has also seen the river where he threw a shirt but shirt was also not recovered. Exhibit 81 is the discovery of the fact dated 1195 was prepared in my presence and in presence of summoned by CBI officer. 81 1 and 81 are my signature on Exhibit 81. Exhibit 8134 are the signature summoned who put in his signature in my presence. I identified his signature. Accused soldiers of my last master put his thumb impression on Exhibit 81 in my presence and person who accompanied us. Material Exhibit 14 is the broken rifle which was recovered on the spot as led by the accused Robert Sakma, last master, and Kalishan Sakma. I identified the same today in the court. Material Exhibit 15 is the rifle recovered on the spot led by the same accused person. I identified the same today in the court. In the cross-purpose. Today I have not seen the order of the DC by which I was directed to go to CBI camp on 3/9/2005. At about 9 a.m., I went to the CBI camp. I put my signature on Exhibit 78-1 after reaching the content of the Exhibit 78. There are two soldiers who put signature and who put impression, put thumb impression. I don't know. There are two soldiers. One is Huraba and one is Maskolo. Next question. It is not a fact that I did not put signature on Exhibit 78-1, 79-1, and on Exhibit 78 and 79 after reading the content. Exhibit 6 was the prepared on a box which was taken by the CBI official. The material mentioned in the Exhibit 6 were found within a radius to 5 to 6 feet. Articles are recovered with branch of trees and leaves and small bundles. I show when articles were recovered. I put my signature on Exhibit 6 without reading the content as it was prepared Executive Mr. Ashimalagar. It is the important. I put my signature on Exhibit 6 without reading the content as it was prepared by Executive Mr. Ashimalagar. I had not gone through the recovery memo before putting my signature on Exhibit 79. I put my signature on Exhibit 9 after Executive Mr. Ashimalagar put his signature. I did not notice when the other witnesses put signature on Exhibit 9. I have not read the contents of Exhibit 82 as I was asked. I put my signature. I put my signature on Exhibit 83 without going through the content. It is not a fact that without knowing the content, I put my signature on Exhibit 3. I passed SSLC examination. Material Exhibit 15 is the rifle and in its appearance. It appears that Material Exhibit 14 is a broken pieces of gun. I don't know whether articles like Material Exhibit 14, 15 are to be found in any other places and it can be prepared by any other person. Officer told me what is written in Exhibit 18, then I put my signature. It is not a fact that Exhibit 80 was not read over to me. Officer explained the content of Exhibit 81. I did not verify that whatever it is to writing in Exhibit 81. On 4/9/2005, I along with the CBI officer rushed to the Viceroy around 4 in the morning. We set off our journey up to Ramnathpur. We went by the vehicle. Distance between Hailakandi and Ramnathpur is 64 kilometers. Around 5 to 5:30 a.m. we reached Ramnathpur. Viceroy at a distance of 5 to 7 kilometers has Ramnathpur. Viceroy is the place where materials were found. I took around 2 to 3 hours to reach Viceroy to Ramnathpur. Around 9 to 9:30 a.m. we reached the spot. On the journey from Viceroy on the spot, we took rest for about 10 to 15 minutes. I don't remember how much time took in the finding the article. I don't remember whether there were damages in the skull as it was intact. A machine was found. CBI official told it is a pacemaker. I don't know whether bones were recovered, human bones or not. It is not a fact that I deposed false evidence on tutor. Now let's take page number 157, PW number 20.
Page?
Page number 157. PW number 20. Tapan Kumar Bro. Very good. I I am doing the business of hardware at Selenga Bazaar. I used to maintain accounts of my business in Bengali language. On 9/6/1411 in Bengali calendar, purchased one golden ring from Kalijoy Sakma at rupees 1000, and that was recorded in my account book by exhibit 11 containing 7 pages. The 11 entry in my page number 2 by exhibit to 11.2 is in 11.1. I also purchased one golden ring from Urban Sakma at rupees 600. Ring was studded with wild stone. This purchase was also recorded in my account book in Bohikhata. By exhibit 11.4. In exhibit 11.3 and 5 are my signature in the book. I put this signature when the said golden rings were seized by CBI on 9/9/2005. At the time of seizure, other persons were also present. CBI on the same day came to me to inquire about the golden chain, which Sahadev Sakma sold me at rupees 10,000. On 29/1/2004, that golden chain was taken by the wife of the Sahadev Sakma after paying rupees 10,000 to me. So the CBI did not find the golden chain which with me. I have identified the accused pointing the finger at Sahadev Sakma. After seizure of the golden ring, the CBI prepared the seizure memo by exhibit 16 and put my signature by exhibit 2 and 63 on 995. Metal exhibit 2 is the golden ring with red stone. Metal exhibit 3 is the golden ring with off-white stone, grey stone. After seizure of metal exhibit 2, I put my signature by exhibit 2262 dated 995. I put my signature on the envelope by exhibit 31. The metal exhibit 3 was wrapped by me in a paper in a written by mentioning the name of Gunbam Sakma Kalapana Sakma. Exhibit 31 is my handwritten. Exhibit 31/5 is written by saying the name of Gunbam Sakma on 24/9/2005 at rupees 600 for all the content. These writings were written prior to seizure by the CBI. Content of the books are my handwriting. These writings were written prior to seizure by CBI. The signature of the vendor of the golden ring was not taken by me. It was written in the presence of the vendor. On 9/9/5, CBI seized these documents. In the account book, I did not put my signature on the date of seizure. This account book is of 4 years. In the month of Asin, I also recorded the transaction. The transaction of defined dates and recorded, but not in a single book. The seizure list was written by CBI in my presence 9/9/5 in my residence. At that time, about 10 to 12 persons were present. I don't know English. I was told about the content of the seizure list by the CBI. It is not a fact that exhibit 11 was prepared by me on the same day. I used to record the transaction in a loose paper as I am not in a big businessman. It is not a fact that without knowing the content and seizure list, I put my signature.
He claims to have purchased the gold rings.
Yes,
Which gold ring said the prosecution's case is that it belonged to the
this is not. In PWT, that is the gold chain color was white. In the evidence in the PW20 stated the metal exhibit is the golden ring with the red stone. It is the golden ring with the white stone. Page number 164, PW number 23. Dr. B.K. Mahapatro.
page,
Dr. B.K. Mahapatro.
page 1.
164. Is a senior scientific officer, TFSL, CBI. May I read, Dr.?
Yes.
On 4/9/2005, I was serving as a senior scientific officer, CFSL, New Delhi. On 4/9/2005, I was CFSL director to assist the CBI personnel in crime scene investigation purpose. As directed, I came Hailakandi. Arriving on 3/9/2005, for the purpose of collection of evidence in RC case number so and so. On 4/9/2005 at 4 a.m., I accompanied CBI personnel, a local police, one doctor, and one magistrate for Viceroy Hill by a vehicle from the railway station, and therefrom we went on a foot. Two accused persons also accompanied us, and their faces were covered. We crossed by river by country, boat, and about 9 a.m. we reached the spot which was located in a Viceroy Hill. The area was full of jungle, covered by bamboo and trees. After climbing the hill about 1,000 feet high, we reached the bank of a small rivulet where we saw some barns scattered on the in the slope of the hill. Two shirts, two pants, one pacemaker, one wallet, two pair of shoes, two elastic belt, one pair of softball, and some soft tissues-like material. After gathering these materials, the CBI personnel seized those articles. The recovery memo was prepared in the presence of me, Sri Kamal Chauhan, Mr. Asim Malakar, N.P. Yadav, Asit Dev, Subroto De, S.K. Mishra, and Sudip De. S.K. Mishra and Sudip Dev, the two accused were also present at that time. Exhibit 714 is my signature in the recovery memo. Exhibit 715 is the signature of Kamal Chauhan and the assistant CFSL Delhi, who also accompanied us for the place of recovery. The materials were still packed with law in my presence. These articles were not sent to me by division of CFSL. Exhibit 91 is the production memo and the sketch. 91, 1 and 92 are my signature in the production memo. On 8/9/2005, one Mr. Kebil Morton, Detective Superintendent Scientific Super Manager, South Yorkshire Police UK, produced blood sample. It was given in presence of Mr. M.S. Patial, Inspector of Police, CBI. The sample was blood-stained, cut, and two steel tubes snip lead containing blood sample of Mrs. Shivani Dev bearing identification number so-and-so. The other articles were one plastic container bearing reference number so-and-so. That is the important logic. The sample was blood-stained, cut, and two steel tubes snip relating blood sample of Mrs. Shivani Dev, who happens to be the wife of the deceased Procedural. There is no any documented evidence to show that Shivani Devi is the wife of the Procedural, this is Procedural Dev.
Now, why this sample was taken?
For DNA profiling.
So she is what?
She is a wife.
Wife.
Wife, Shivani Devi.
DNA profiling for what purpose? Wife?
Wife.
Why wife? How is it connected?
So lordship is the other evidence of
Yes,
the
sir.
scientific expert.
Not the son or the daughter
Yes,
So-
this Shivani Devi is
Blood sample has also been collected.
of son or daughter.
Daughter.
But why wife's blood sample? What DNA profiling? Who's the better?
prosper. At about noon, we reached the Viceroy Hill. From the Camp Hailakandi, we went by vehicle and reached by the railway station after about 1 to 2 hours. The recovered articles were brought the camp. The recovery articles memo was prepared at the spot and other in the camp because bones had to be cleaned. I put my signature in the camp. Lordship, may refer to PW 26, page number 172. Dr. T.D. Dukra is the head of the Department of Forensic Medicine, AIMS, New Delhi.
What was the role of this V.K. Mahapatra, scientific officer?
Yes, Lordship.
What was the role of PW 23?
B.K. Mahapatra. He has
Yes.
collected some blood samples and so it is available in the exhibit part. I will put it.
So what was the purpose of he being a witness?
Yeah.
The person who had collected, he's also been cited as a witness.
Yes.
Who had done the examination later on? Somebody else?
Yes, Dr.
Dr. T.D. Dogra.
Dukra. He is the head of the Department of Forensic Medicine, AIMS, New Delhi. May I read, Lordship?
Please.
During the year 2005, I was posted at All India Institute of Medical Sciences, New Delhi, as head of the Department of Forensic Medicine. I received a message from the CBI for conducting a autopsy skeleton image. I also received the inventory along with the sample and seal. Exhibit 105 is the letter dated 995 given by Mr. M.S. Patel. A notice to me requesting to autopsy a skeleton on this CBI case number so and so. Along with the said letter, sent an inventory consisting a total 12 exhibits received in a seal cover, and along with the said packet and seal specimen had also been sent to me. Exhibit 106 is my signature along with the seal as a professor and head of the Department of Forensic Science. Exhibit 1062 is the inventory listing 12 exhibits. Exhibit 107 is the letter dated 12/9/2005 given to me by Mr. M.S. Patel, Inspector of Police CBI, whereby the detailed record of deceased total death was provided to me and closed with the letter dated 12/9/2005. Exhibit 107 is my signature whereby I received the dental record of deceased PC Dev and listing 6 documents. Exhibit 107 is the said list to me collect the blood sample of Mrs. Shivani Dev, wife of Mr. Pratul Dev, along with a consent letter signed by Mrs. Shivani Dev. Exhibit 1110 is the signature of Dr. Sanjeev Lalwani, who has received the said letter. Exhibit 1010-2 is the consent letter of Mrs. Shivani Dev. Accordingly, I acted to take the blood sample. Exhibit 111 is the specimen of seal and impression, the seal packet whereby the sample of the blood was collected. Exhibit 11-1 is the signature of Dr. Shiktaranjan Behera, senior resident of Department of Forensic Medicine at the time of AIMS, New Delhi. After receiving the request, I constituted a board by requesting the doctor and head of the Department of Anatomy to depose one faculty member and one head of the general surgery to depose and the faculty, and accordingly he deported Mrs. S.B. Ras, additional professor of anatomy, and Dr. Jotin, senior resident of dental surgeon. I also included Dr. Sanjeev Lalwani, assistant professor. Exhibit 108 is the letter by CBI by Mr. M.S. Patel with the request for collecting the blood sample of Miss Shipra Dev, the daughter of Chief Pratul Dev, enclosed with the consent by Mrs. Shipra Dev. Exhibit 1A is my signature whereby I received the sealed letter. Exhibit 1082 is the consent letter of Miss Shipra Dev. Exhibit 109 is the letter dated 13/9/2005 given by Sri Ramnath Behera, DIG of Police CBI, requesting for DNA extraction at CDFD Hyderabad for DNA materialing and requesting the deputation of Dr. Anupam Raina for Forensic Medicine Department aims for extracting DNA analysis to CDFD Hyderabad as requested by Director CDFD Hyderabad. He also requested for photograph of the skeleton remains. Though requested to
Extract.
extract DNA from the skeleton remains of Sadhanath, I proceeded accordingly in this case. Exhibit 110 is the letter signed by M.S. Patel, Inspector of Police, my department, and Dr. Chittaranjan Behera of my department. The examination was conducted and the report was prepared, which was handed over to CBI on 15/10/2005. The report of Exhibit 112, the Exhibit 112 is 8 pages and signed by myself, Dr. Sanjeev Lalwani, Dr. Jatha, Dr. Chittaranjan Behera, Dr. S.P. Day. At the time of submitting his report on live tenants, I have a set one was handed over to Dr. Anupam Raina for scientist for DNA fingerprinting of my department. Along with his report, 8 annexure along with a list of annexure was handed over to CBI. This report concludes the identical features of notable skull and other bones are set up and suggests that the supplied materials could be heavily built elderly person and as it about 16 years or above, the whose don't denote death, nasal and teeth available are appeared to be something well above outstanding dental and mentioned in the record of Mr. Pratul Dev as provided by the CBI. The details of pacemaker of Mr. Pratul Dev from Hammond Smith and dated 6/10 as provided by the CBI is also matched with the number of the pacemakers submitted by the Exhibit 12. The cause of death could be ascertained on examination of skeleton remains. Photograph of skeleton was taken. The bones of eye was handed over. A CBI by letter number so and so. The size of this state was in an adult male. I sent the report by letter number dated 15/9/2005, which is the Exhibit 114. Exhibit 114 is my signature. 14.2 is the sign on the annexure containing annexure. Exhibit 14.3 is my signature. 14.4 is the signature Dr. Sanjeev Lalwani. 112 to 8 is my signature on back pages of the report. exhibit 112-9 to exhibit 112-16 either signature of Dr. Chitranjan Behera, exhibit 112-7 to exhibit 112-25 either signature of Dr. Sanjeev Lalwani, exhibit 11 112-26
You
to
can skip
112.
this, you can skip this. You can skip the signature part.
Yes, sir. I said signature. Either signature of Dr. Chitranjan Behera.
The next 175 skeleton remains of the set of 2 were handed over. What was the finding of the skeleton remains?
Skeleton remains protected.
Any positive finding?
No, no.
No finding.
I'll put a exhibitor. May complete the evidence. 170 signature of Dr. Jotin. The doctor, the then senior resident of the dental surgery and the state report. The skeleton remains of set 2 was handed over to CBI by letter number 23-5 by exhibit number 103, which the signature, and exhibit 103 was my 113 is my signature. The sheet 1 I was returned back on 16-17. So Sri Sunil Kumar by letter number 115. Exhibit 15-6, 15-2 are the two signatures Mr. Sunil Kumar, Inspector of CBI, SCR, 3 Delhi, who received the partial of skeleton remains of set I. Exhibit 13-2 is the skeleton still in impression where is the eligible of set 2 was returned back. Exhibit 13-3 is the signature of Dr. Chitranjan Behera. Exhibit 116 is the eligible recorded bin MR number 1198, which is the open in presence of detective. After satisfying that the seal is okay, the packet carries one envelope by exhibit 116 in which pacemaker was sent to me. Material exhibit 51 is the seat pacemaker. Exhibit 116-2 is the signature of Dr. Chitranjan Behera on the seal packet containing the pacemaker. 117 is the letter dated 19/9/2005 written by me to Mr. Lakhan Behera, DIG CBI SCR, by which requested him to arrange the air ticket from Delhi to Hyderabad and back to Dr. Nipen Raina, who was the requested to call ASQ, ACL, CDFT Hyderabad. Accordingly, the CBI provided the tickets. Exhibit 117 was is my signature. Exhibit 118 is the letter bearing number so and so, dated 29/3/95, written to me by CDFD by CSB Gold, Technical Executive CDFD, regarding sending back to the bone to me after examining and all sharing that 2 samples are blood samples of Mrs. Chipradev and Mrs. Timothy Shivanandev were collected. This letter also bear the testified seal of CDFD Hyderabad. This letter was sent to Nipen Raina. Exhibit 108-1 is my signature on letter dated 23/9/2005, whereby I received the from CDFD. Exhibit 119 is the letter written by CSB Board Technical Executive on CDFD acknowledging on receipt of the letter.
Mr. Datta, why don't you reading everything will take a lot of time. Why don't you read the relevant part?
Yes, sir.
Because you need to complete today. What are the relevant parts by which the prosecution claims that your client is also involved?
Yes, sir. Now I am going to the exhibit part. Part 2, volume 2. Two.
Volume 2, part 2. Part 2. Part 2, volume 2.
Yes, sir. Page number 252, Lord. Part 2.
Corrected page.
No, that's it. Production memo, Lord.
Corrected page.
Production.
Pages are correct. There are 2 page numbers. That is why you are asking.
Yes, sir. 252 production memo, Lord. CBL New Delhi production memo.
Yes.
This is the production memo, Lord Sir.
Hmm.
May I look.
Yes. Yes.
I, Kevin Morton, Detective Superintendent, Scientific Support Manager, Police Headquarters, South Exeter Police, Ning Hill, Sheffield, so and so. Presently at Delhi, do hereby hand over the following documents and exhibit to Mr. M.S. Patil, Inspector of Police, Special Crime Division 3, CBI, 7th floor, so and so, New Delhi, with an authority to use and utilize the same in connection with the investigation of CBI case number so and so. Serial number 6, Lord Sir. One polystyrene box containing the following samples collected from Mrs. Sabanidev with her constant blood, stain, cut, and two steel tubes with the snap lids of so and so containing blood sample of Mrs. Sabanidev bearing identification number so and so, and one plastic containing bearing number so and so. 6.
Yes.
Yes. They have handed over the same to the CBI on 8/9/2005.
This is from
From-
South Yorkshire.
Directed to CBI. Now let's page number 297. Request for autopsy report.
That's in code. Now, how is the blood sample of Shivani Dev material in this
Is
case?
for they have collected for DNA profiling.
Now, how is it material? That we have understood for DNA profiling. Shivani is the
They-
daughter or the
No,
wife?
Shivani is not the wife. It is the wife of the deceased. They have neither.
Wife of the
Yes, that is the correct. The Yorkshire,
what will the wife of DNA of the wife has
Yes,
got to
sir.
do with the deceased?
in India, when they have collected the blood samples of Cipradev in AIMS, in India AIMS, the CDFD reported that DNA has not been matched with the Shivani Cipradev. Later they have the CBI sent the communication to the Yorkshire police for profiling for further investigation for further DNA profiling.
Is it how will there be a connect of the wife's
Yes,
DNA
that is
with the husband's DNA?
yes. Is the important of the version? Either son or just daughter.
They have to be either of the offspring or the
Yes, sir.
father
That is-
or the mother. And that too to the UK police.
In Yorkshire police, they have not collected the blood samples of the Cipradev. In India, the CBI have collected the blood samples of the Cipradev,
The daughter.
the daughter of the.
What was the DNA in the separatives?
In India, Lordship, that is a page number 329, Lordship,
Of this
of this
compilation?
volume, Lordship,
Of this compilation, 329.
329.
Yes.
Yes. May-
DNA typing.
Yes. CDFT Center for DNA Fingerprinting and the Diagnosis. To Dr. T.D. Dogra, Professor, and to subject submission of DNA typing report in CBI case number so and so regarding result of examination and conclusion. The sources, all the above exhibits were subjected to DNA isolation. However, the sources of exhibit A, bone, exhibit B, exhibit E, pertaining to the deceased AL, a highly degraded DNA which did not give any DNA profile. A lordship, there is a chart lordship. A, bone said to be the deceased one. B is the teeth. C is the blood sample said to be Miss Shipradev. Blood samples. D is the blood sample of Mrs. Shivani Dev. E is the blood bone said to be deceased 2 lordship. And the result is that the sources, all the above exhibits were subjected to DNA isolation. However, the sources of exhibit A, bone, exhibit B, teeth, and exhibit E, bone, pertaining to the deceased AL, a highly degraded, and DNA which did not give any DNA profile. Amplifying F to ensure identify as well. Since the DNA profile from the sources of any exhibit A, bone, exhibit B, and exhibit is essential to compare, no opinion is being furnished here. This is the report of the CDFT Hyderabad. The CBI has not relied this opinion. Therefore, they have communicated to the Yorkshire police for further DNA profiling.
No, oh, see, this DNA, it was reasonable because there were two bones of the remains
Yes,
and 3 teeth,
yes, sir.
along with the blood samples of, I don't know why wife, but even the daughter.
Yes.
But so far as the deceased is concerned,
Yes.
the conclusion could not be arrived at.
Yes.
Because it was highly degraded DNA.
Yes.
So there is no result.
Yes.
So if you send for on a further DNA profiling,
Yes.
you have to send either the bones or the teeth of the deceased and match with the DNA of the daughter,
Yes, sir.
which has not been done to the Yorkshire. So how is it? How? What are the materials for the prosecution to come to a conclusion that the skeletal remains is
Yes.
of the deceased?
Yes.
What,
There is none.
Is there any material?
No, there is none. They have not realized this the opinion of CDMT.
No, here there is no opinion.
Yes, sir.
Because it's a highly
It is
degraded,
degraded.
there is no opinion. We cannot
Yes,
give an opinion. So, rightly. Okay, we'll come back at 2 o'clock, but we have to finish it today.
Okay.
Because we need to rise slightly early.
Yes, sir.
I thought if I have concluded the argument, the lordship will require any clarification. Because my friend will begin the argument.
Yes.
No, I will not today, proceed with my, if some of the, they are not there.
Oh, Monday, will be difficult. Bench will not be there.
Only on fact, but
Monday will be difficult. You have to finish this week.
they can.
Otherwise, 2 days,
Thursday,
2
they
days
can-
hearing will go waste.
It be on Thursday.
Thursday we'll try. But today, let Mr.
Yes,
Doctor
sir.
complete.
Let them complete.
Okay, hold on. Okay, hold on.
Practical to remember internet. Volunteer opinion. Yeah, main কথা হ'ল disclosure to voluntarily হয় নে নাই সেইটো চাব লাগিব। ঠিক আছে।
Autopsy report.
The last page.
Last page.
Hmm.
No, may it no cause of death could be ascertained on the examination of skeleton remains. Photographs of the skeleton were taken. It was reported at 27/9/2005.
Now, how do you decipher a cause of death from the skeletal remains after 1.5 years? Nothing. Only even DNA could not be ascertained.
Yes. Now I'm referring page number 346.
But here in this page, Mr. Datta, there is something, just one paragraph above that. The details of the pacemaker
Yes, Lordship.
of Sri Pratul Dev
Yes,
from so-and-so hospital
yes, Lordship.
as provided by CBI also matches with that pacemaker submitted by CBI.
Yes, in the Lordship, in the inquest report, in the pacemaker, there is no any serial number, model number. In the inquest report, in the pacemaker, there has not any Lordship model number. In every serial number has a different model number. There is not mentioned anything about the model number of the pacemaker. In every model number, there is a different serial number. This is my humble submission. Therefore, I pray before this number is not related with the portal. Inquest report, page number. Inquest was done on 4/9/2005. Part 2, volume 1, page number 25 and 20. No model number. Now I'm referring to page number 346.
Page.
Page 346. Same volume.
Yes.
Yes, it is written by Superintendent of Police CBI to the Kevin Morton, Detective Superintendent, South Exeter Police, England Lordship, which requested forwarding bone samples of comparison of blood sample of DNA analysis in CBI case number so and so. In relevant page number 347, first paragraph, Lordship. The fresh blood samples of in respect of Dr. Sipra Dev, the daughter and Srimati Shivani Dev, the wife of the Patul Chandra Dev, who are residing at 148 totally Brook Road, Sheffield, Association, United Kingdom, may be collected from there itself. They have requested Kevin Morton to collect the blood sample of Dr. Sipra Dev and Mrs. Shivani Dev. After thereafter, in the record, it is revealed that the Yorkshire police have not collected the blood samples of Chipra Dev. They have collected the blood samples of Shivani Dev also. That is available in page number 350 or 354. It is the statement of Shivani Dev. Shivani Dev, I am the above named person and resided at this Oval at 2550 hours on Monday, 5 September 2005. I attended at my daughter's home address so and so at 9 hours. That day I saw Dr. Loinis in the front road of the above address. There I provide one blood sample of Dr. Loinis. Placed the blood sample in a sealed container which was then placed into a police evidence in clear bag. The evidence bag was still in my presence bearing an exhibit number so and so. Dr. Loinis then handed the steel bag containing the blood samples of PS and who took the possession of it. The Yorkshire police had not collected the blood samples of the Dr. Shipra, who happens to be the daughter of the deceased Patul. They have collected the blood samples of wife of the deceased Shivani Dev.
Yes.
From the face of the record, it is apparent there is no documentary evidence to show that the Yorkshire police have collected the blood samples of Shivani Dev in England, in UK. And the report of the Yorkshire police that is available in the page number 379.
379.
379.
Yes, 379.
Yes. Where it is a statistical evaluation of result. This is the forensic science service of Timothy Mark Clayton, BSc. In carrying out a statistical evaluation of this result, I have considered the following alternative explanation for the results obtained. Either the female born 176 is from the biological father of Pipradeep, or the femur born is from an unknown Indian woman who is unrelated to Shipradev. Using data available from the population of the Indian population of the United Kingdom, a figure has been calculated called the likelihood ratio. This is a numeric evaluation of the strength of the DNA evidence. The higher this figure, the greater the degree of support of the proposed relationship. In this case, the figure is approximately 7,000. And the conclusion part, that's it, page number 380. Conclusion, in my opinion, the results detailed above provided strong support for the view that the femur brain 176 originated from Chipradev's biological father. I am unable to determine whether or not the femur brain 178 originated from Sadhana.
What is it? What is the meaning?
I am unable to
No, in my opinion, the results detailed above provide strong support.
for the view that the femur brain 179 originated from Chipradev's biological father.
Oh.
Total Chipradev's father.
But what was matched with Cipra?
There is no in document. There is no any document that the Chipradev is the daughter of the later. This is total depth.
No. What was the sample of Cipra so that matching was
Okay.
done?
Yes. It is as per that is not available in the record.
I didn't even. There.
Lordship sees the evidence of this examiner dot. Page number 340, exhibit 17. 340. With the polls of the court. Okay.
We have just seen
He was examined.
346. 346 you just referred.
So he was examined. Also.
347, which volume?
No.
Which volume?
Timothy Mark client Lordship paper.
Oh, not part 2, part 1.
Part one. Lordship sees the evidence of that.
Okay, we'll come to you when.
In the entire case of Dr. Chipradev, put her signature along with her address in the 3 documents. That is Exhibit 108, page number 304, Lordship. In Exhibit 167, page number 393, and Exhibit 168, page number 394 of the document in Part 2, Volume 2. But nowhere she mentioned that she is the daughter of the Protul Dev. She has, in the entire case of Dr. Chipradev, put her signature in 3 documents. Neither she has stated daughter of Protul Dev. Neither the prosecution has to establish that Chipradev is the daughter of the late deceased Protul Dev. They have not cited as a witness in this case.
No, is it a matter of dispute that Shipradev is not
There
the...
is no any document to
No,
suggest.
is it disputed that Shipra is the daughter of Protul
From the face of the record, it is apparent that there is no any document to say Chipradev is the daughter.
No, are you disputing
Yes, sir.
that Shipra is the daughter?
No, it is not the daughter. There is no document to store the daughter. The Chipradev is the daughter of the deceased
Then
Protul
who
Dev.
filed the PIL?
Environment Legal Protection Society, Lord. One NGO, Lord. Assam Environment Legal Protection Society, Lord. PL number 48 of 2004.
Order?
Order dated, Lordship, disposed on 12.
No, page.
That is not in the record. And it was disposed on 12 for 2005.
Yes.
In my confessional statement, Lordship, it is in part 2, volume 1. My
Mhm.
confessional statement was recorded in 12/9/2005.
Page,
Page Lordship, part 2, volume 1, page number 10.
part 2, volume 1.
Part 2, volume 1. Lordship. Page number 1022, what people on.
Page,
Page 102 starts from 102. Lordship. And 11 pages, Lordship, page number 108. 11. In this case, I have to state, submit before this noble court date. There was not, I have not mentioned about the date on which date I have kidnapped the deceased couple on the date of it in the confessional my statement. In the confessional statement, there is not mentioned the date on which date they have murdered the deceased couple on the date. In the confessional statement, there is not mention about the place wherein they have committed the alleged offense. In the confessional statement, I have not mentioned about the confessional statement regarding disclosure statement leading to discovery, the bonds, etc. Had I voluntarily confessed about the commission of offense, then I would certainly mention about the lead to discovery, the place wherein the alleged offense was committed, and recovery of the bonds. Pacemaker was recovered, golden sin. Moreover, all the process were completed before regarding confessional statement. Therefore, it cannot be said that a confessional statement was volunteered.
this is the confession of whom?
Sorry, took my last Corroboration. It was recorded on 12/9/2005. My leading to discovery, Lordship, and all the process were completed before recording the confessional statement. Had I voluntarily confessed before the Honorable Learned Trial Court, Learned Magistrate, then I would certainly state it before all these things before the Learned Magistrate. Therefore, it cannot be said that the statement was voluntarily given.
No, confession is regard to what? Commission of the offense.
Offense, sir.
After the event which had taken place after the offense
Yes.
is not essentially a relevant part of the confessional statement. We are more interested to see whether his involvement with the commission of offense has been accepted.
Yep.
Whether he was there in the disclosure part,
Yes.
recovery part, then
Leading to
yes,
discovery.
you may be correct in saying that where the offense was committed, which date.
Date, place, nobody was mentioned. Lordship. Had I voluntarily stated before the Learned Magistrate, then I would certainly stated all these things. Lordship. And I have also detected the same in my SD, Lordship, in my statement of defense. In question number 299 to 279, detected in SD. Part 1, volume 3, Lordship, in detection. Lordship.
Page?
Page, Lordship, 299 to 292, Lordship, 309. Part 2, part 1, volume 2. In my it had, I have it checked. At last, if this honorable court may not consider my appeal on merit, therefore this honorable court may prefer to conversion the punishment for life to 20 years. In this regard, I would like to refer the judgment. Honorable apex court. My alternate argument, if this honorable court may not consider my argument on merit, this honorable court has the power to convert the punishment from life to 20 years. In this regard, I would like to refer the judgment of honorable apex court. 2016-7.
But what is the prescribed penalty?
Lordship,
What is the prescribed penalty?
penalty lordship, life imprisonment.
So can we do anything else?
In this secret, I would like to refer the judgment, Lord. In the honorable
Sure.
court.
But there are many other judgments.
Yes, sir. In the
Whatever is prescribed, we cannot, it's up to the legislature to prescribe the penalty.
Yes.
We cannot alter the penalty.
in this secret, I would like to refer. Paragraph number 101, Lord. The alternate argument. May I read, Lord?
Paragraph
101. That's from Union of India versus DC.
101.
101. May I read, Lord?
One zero one.
101 to 105. May I read, Lord?
Just a minute.
Yes.
Yes.
Thus, prescription contained in the criminal procedure code, though procedural, the substantive part rests in the penal code for the ultimate confirmation or the modification or alteration or amendment of the punishment. Therefore, what is apparent is that imposition of a death penalty or life imprisonment is substantially provided for in the penal code. Procedural part of it is prescribed in the criminal procedure code, and significantly one does not conflict with the other. Having regard to such dichotomy being set out in the penal code and the criminal procedure code, which in many respects to be operated upon in the execution of a criminal case. The result of such truly undefined defined distinctive features have to be clearly understood while operating definite provisions, in particular the provisions in the penal code providing for capital punishment in the alternative, the life imprisonment. 102. Once we stare, clears the such distinctive features in the two enactments, one substantive and other procedural. One will have to have no hurdle for difficulty in working out the different provisions in the two different enactments without doing any violence to one or other. Having thus noted the above aspects on the punishment prescription in the penal code and the procedural prescription in the criminal procedure code, we can authoritatively state that the power derived by the court of the law in the various specific provisions in providing for imposition of capital punishment in penal code, such power can be appropriately exercised by the executing court in the manner of the ultimate imposition of the punishment in such a way to ensure that the order procedural remission, commission, suspension, etc. on the prescribed authority, not speaking of similar power under Article 72 and 162 of the Constitution, which are untouchable, cannot be liable to be or can be in any manner overlap the power already exercised by the Court of Justice. 103. In fact, while saying so, we must also point out that such exercise of power in the imposition of death penalty or life imprisonment by the session judge will get the scrutiny by the division bench of the High Court mandatorily when the penalty is death, and inevitably, even in the respect of life imprisonment gets scrutinized by the division bench by virtue of the appeal remedy provided in the criminal procedure code. Therefore, in our conclusion that above can reinforce by stating that the punishment part of such specified provision offences are always examined at least once after the session was verdictly by the High Court, and that two by the division bench, consisting of two honorable judges. That 104. Therefore, in most of these such cases, where death penalty or life imprisonment is punishment imposed by the trial court and that confirmed by the division bench of the High Court, the convict contract will get an opportunity to get such verdict instead by filing further appeal by way of a special leave to this court. By way of the abundant question as per the prescribed law of the court and the criminal jurisprudence, we can assert that after the initial
You are reading which paragraph now?
104.
Yes.
That after the page number 102.
Yes.
Initial finding of guilt, thus specified grave offences and the imposition of penalty either death or life imprisonment. When it comes under the scrutiny of the division bench of the High Court, it is only the High Court which derives the power under the penal code, which prescribes the capital and the alternate punishment to alter the state punishment with one either for the entirely for the convict's life or for any specific period of more than 14 years, say 20, 30 or so, and depending upon the gravity of the crime committed and the exercise of judicial conscience and befitting such offences would prove to have been committed. This court has the power to alternative punishment per person. I am behind the bar 19 years, 6 months, 13 days, is on that lawsuit. And 105 lawsuit. We therefore reiterated the power derived from the penal code for the modified punishment within the punishment provided for the penal code for such specific offences can only by the exercise by the High Court and in the event of further appeal only by the Supreme Court and not by any other court in this country. To put it differently, the power to impose a modified punishment providing for any specific term or incarceration or till the ends of a convict's life as an alternate to death penalty can be exercised only by the High Court and the Supreme Court and not by any other inferior court. My alternate argument is that this honorable court has the power to modify the punishment law.
You come to the question number 1 and 2 at page 64 of the judgment. The first two questions.
Question number 1 and 2, Lordship.
Yes.
As to whether the imprisonment for life means till the end of the convict's life or without any scope for the remission. Second, whether a special category of sentence instead of death or for a term exceeding 14 years can be made by putting that category beyond grant of remission law.
How the first question has been answered? Remission power is of the
Is the
president and the governor.
Yes, sir.
So how, that's a different concept
Yes.
altogether. Even a life convict can
Yes.
be given the benefit of remission, but
Yes.
that is by the appropriate authority,
Yes, sir.
by state,
Yes.
not through a court. Court can direct consideration of a remission
Yes.
application. But where is the power to reduce?
Yes, sir. It is, my humble submission is the page number 1, paragraph number 104.
But if life means till the end of the convict's life, 104.
104. Page number 101. Where is it?
One zero four. What is the statute? Which provision of the statute has been
50.
referred?
57.
Hmm? 57 of
IPC.
IPC. Yes. What is 57?
Fractions of terms of punishment. In
Yeah.
calculating fraction terms of punishment, imprisonment for life shall be reckoned as equivalent to imprisonment for 20.
Fractions of terms of punishment. Then what about the judicial pronouncements? Life means life. How do you reconcile? Even in this case, 5 judges bench very clearly said এখানে মানে কোন আছে একটুই পাবি হেরি আছে না What is the meaning of this problem? Permission power is up to the government, so that we can review different documents. Calculating fractions of terms of punishments. What is the meaning of 57?
Sections of terms for imprisonment.
Terms of punishment.
From-
What is the meaning? What is the meaning
In
of fraction?
calculating fractions of terms for punishment, imprisonment for life will be reckoned as equivalent to the imprisonment
That
for
means how do you why do you calculate fractions of terms? What is the meaning?
penalty.
See, 55, if you read 55,
Yes, sir.
and for that matter 54 also,
Yes.
how do you commute a sentence of death? If the appropriate government wants, then without even the consent of the offender
Yes.
can commute.
Yes.
And so far as a life
Yes.
sentence is there, it can be commuted to a description for a term not exceeding 14 years.
Yes.
So those are
By the government.
exceptional circumstances and powers are vested with the government,
Yes.
appropriate government.
Yes.
Now, so far as when 57 is concerned, what is 57? Then what would be the meaning of life imprisonment? If you have just read the case which you have referred, the Constitution Bench.
Yes.
After referring to Swami Sradananda,
Yes.
I'm just giving you the paragraph. Up to 52, paragraph 52 of this judgment. Maruram has also been discussed. You read the explanation in paragraph 60. 60, that this 57 has been explained in paragraph 60.
Justice, in Subhash Chandra versus Istanbul, this court followed the courts and the Rotan Singh and held that a sentence for life means a sentence for entire life of the prisoner unless the appropriate government chooses to exercise his discretion or to remit either to the whole or part of the sentence under section 41 of the Criminal Procedure Code 1898. Whereas 29 can include 20. Section 57 of the Penal Code provides that in calculating fractions of terms of punishment, imprisonment for life shall be reckoned or equivalent to the imprisonment for 20 years. It does not say that the transportation for life shall be deemed to be for 20 years. The position of law is that unless the life imprisonment is committed or remitted by the appropriate authority under the 11 provisions of law applicable in the case, a prisoner sentenced to life imprisonment is bound
Yes.
in law to serve the
Only
life.
when remission is then you calculating the fractions, it can be reckoned to be equivalent to 20 years.
20.
Not, this is not the meaning which you are supposed to give. 57 cannot be read in isolation. And the earlier the transportation of life has
Yes,
been
sir.
removed now.
Yes, sir.
Come to page 60, paragraph 61. 61 has answered the question after discussing everything. This is the constitution bench, 61. Please read. Having noted.
Having noted the above report to Constitution Bench decision in Godse and Moruram, which were constitutionally the followed the subsequent decision in Sambhaji Kishan, Ratan Singh, Ranjit Singh, Ashok Kumar, and Subhash Chandra. This the first part of the first question can be section 53.
Conveniently answered.
Yes.
Conveniently answered. That line you have missing.
Yes,
The first part of the first can be conveniently answered.
Yes, sir.
Please
Yes.
read. It will be
Answer to the effect imprisonment for life in terms of the section 50 45 the penal code only means imprisonment for rest of the life of the prisoner subject. However, to the right of claim remission except as provided under Article 72 and 116 of the Constitution to be accessible by the President and the Governor of the state and also be provided under section 432 of the Criminal Procedure Code.
See,
Yes. 62. As far as remission are concerned, it consists
this
of
is remission. Once the excess of remission comes, then the fraction part would come, that 20 years. Otherwise, life is life. And if the prescription of law does not authorize for imposition of anything else, how can we? The second part of your submission perhaps may not have a legal basis. 57 cannot be just plucked from this IPC. 57 has to be read along with the other provisions.
And regarding what is section 428 of this is judgment, in my judgment that as the apostate conviction is judgment part of it, that has already been argued by the Esborgo High, that I can relate it as judgment also. 428 part. I am relying on the disclosure statement made by the argument led by the Esborgo and Esborgo part. This is my humble point. Regarding disclosure and other parts argued by the Esborgo, I am relying on that.
Yes, yes. Yes, you're for, today it might not be possible, you're for which matter?
Proven check.
Huh?
Connected account.
How many appeals are there? 4 appeals?
4 appeal. Criminal appeal 50.
Okay. 3 are over. Your part, we have to do it when? Tomorrow? How long will you take? Or
Tomorrow, my lord, it won't be possible because I'm really out of this.
but this bench,
Thursday, if possible. Day after tomorrow. See on Thursday.
day after tomorrow. But day after tomorrow, see, your part has already been covered.
My lord, my lord. he has
If there
already
are
covered.
certain
I'll just
special
point out my 2 points regarding disclosure and confession on my part. I'll
disclosure confession has been extensively argued, but if you have got anything which is
Not covered.
which is only applicable to your clients, then you
Yes.
can show those.
Yes, my part.
Otherwise,
my-
please don't repeat, because we want to hear Mr. Haloi and finish off the.
my
Okay.
lord.
We, as Borgohain, learned counsel for one of the appellant has concluded his argument. No, so say as Borgohain, comma, Sri P. Kotoki and Sri P. Datta, learned counsel for 3 of the appellants have concluded their arguments. Post up list for further consideration on Thursday. Okay.
Number 18 and at 18 and total start. Can it be next week, Milord? Any date, Milord, next week. Any date.
Conviction under what?
First one is matrimonial, I am for wife, Milord.
Other side,
Second one is Milord, dishonorable court initially Milord directed.
other side, who's for the other side?
Milord, the 50 prosecutor, Milord, and
Matrimonial,
matrimonial, Milord. I will inform, they are cooperating, Milord.
okay, we'll have a date next week.
Next week. Keep the
Rest, we'll give dates, if it's urgent, you can ask for a date, court master will give.
Like-
Yeah, single bench. Single bench will sit, but long matters may not be possible. There is a meeting today. Okay, we'll just come after 5 minutes. No, at 3, no? 3, okay, 3 o'clock.
Later time.
जल्दी
Yes, madam. And I have petition has to be cleared.
Hmm?
My lord, I would like to place something because Mr. The petition has already submitted his document. My lord, there were three
Yes,
points.
your part is already over.
The 3 points, my lord, they have raised last time was that the 2008 office memorandum, for which, my lord, I would like to take to my additional affidavit, annexure 2.
What were the facts?
The facts was
There are
that
40 petitioners.
40 petitioners,
Then the post involved is post of Sahab
Sahib.
in the Kokrajhar electrical circle where
Yes, ma'am.
73 posts were advertised.
Yes, ma'am.
Then they participated, not selected.
Yes, ma'am.
They said that there are two sources.
2 years, 2
One is a direct recruit,
Yes.
ITI diploma,
Yes, ma'am.
and the other is in-house.
Yes, ma'am.
And they, according to them, it should be on a 50-50 basis.
Yes, ma'am.
And they ultimately claim that the persons who have been given the benefit of appointment has secured lesser marks than them.
Yes, ma'am.
That is their case.
Yes, ma'am.
What do you have to say?
Yes, ma'am.
And one for petition number 7, PWD quota, no reservation retained. Hmm.
I have brought everything on record. So my lord, first of all, may I refer to my additional affidavit.
Additional affidavit.
Yes, ma'am.
Filed when?
My lord.
Page number?
My lord. Page number 144.
144.
February 2023.
Oh,
My lord, page 154, ma'am.
154.
Yes, ma'am. 144 it starts. I'm referring to page number 150.
Okay. Dated 27th to 23. Yes. Hmm. Yes, what do you want to submit?
Yes, my lord. Before that, my lord, look at the page. My lord, I have highlighted something in the bottom.
Little procedure has been notified, yes.
Yes. So my lord may see at the bottom, there is an office memorandum that has been taken into effect for filling up the Sahayak 2013.
Yes, 2/4/2013
Yes, ma'am. Now page number 154 is that page.
of your affidavit.
Yes, ma'am.
154.
Yes, ma'am.
Second April.
Yes, ma'am. 2nd April 2013. So the selection committee or the office order stated that this would be the office memorandum by which the Sahayak would be selected for the recruitment process will continue.
Yes.
So my lord, may I now prefer? Now, my lord, as per this, to adopt a uniform policy by different selection committee and the APDCL towards selection of candidate for the post of trainee Sahayak, a modality policy has been worked out for compliance of all concerned as shown below.
Hmm.
Eligibility criteria were two, category A and category B. My lord, category A are the petitioner. For them, it is ITI certificate,
Right.
and the category B is a temporary worker engaged in any power
In-
utility to work as Sahayak
In-house.
in-house. My lord, now,
Where is category B?
My lord,
Yes, second
yes,
category, yes.
yes. Now, my lord, at page 157, my lord,
Hmm.
there is a procedure of selection.
157.
Yes, my lord.
One 157.
Yes, my lord.
Yes, what is this?
My lord, the category A says academic qualification, HSLC 10 marks, ITI 10 marks, knowledge, interview 35 plus 25, 60, and physical fitness is 20. My lord.
Yes.
That is 100.
Hmm.
And then the HSC allocation of marks, ITI marks, and the running.
Hmm.
And whereas for category B, my lord, it is different. My lord may see at the bottom. Experience is 20 marks, interview is 35, 25, and physical fitness is common for both.
Hmm. Yes.
Now, my lord, at 158, my lord,
158.
yes, my lord.
Other cases may not be possible today. We have to rise early. We'll try to complete this. Others can leave. But we'll have to complete it before 3:30.
Yes, yes. Yes, ma'am. The selection committee shall prepare one combined merit list with candidates from both the categories on the basis of the marks obtained, containing the names of selected candidates to number of vacancies. My lord, even if both the sources are different, there will be one combined list. And that
Yes.
is what my lord on the last occasion had asked me, that if there is one combined select list,
Yes.
why there is a difference of mark. So, my lord, first of all, the additional affidavit in which the selection they have brought, that is not the actual mark list. My lord, the actual mark list is here, which I have received, which my lord,
Yes.
my lord, this is the actual copy.
Which one?
My lord, there is a forwarding letter, and thereafter, my lord, it's in horizontal
Yes,
pages.
yes, yes.
Yes, my lord.
Yes.
My lord, this is the actual one. My lord, now if my lord see the one which they have produced, there are difference in marks here, my lord. At page annexure B, page 11, my lord,
Of the repetition.
of their additional affidavit, my lord.
Page.
My lord, it will be page 11, my lord.
No, running page.
Running page, additional affidavit received on 25/2/2020
25.
to 2020, my lord. Horizontal page.
Additional affidavit.
Yes, my lord.
Those sheets, mark sheets.
Yes, my lord.
Is it an additional affidavit of 2018?
Yes, ma'am. 117, my lord. Please. 117.
117.
Yes.
Yes, 117 is the affidavit.
Yes, my lord. My lord may see the name Tanam Brahma in the one which my learned petitioner has here's for 87.75. Whereas as the original record which I have produced before my lord,
Hmm.
it is 95.25.
Where are the marks here in your record?
My lord,
You've got the merit position. Marks are also
my
there.
lord, yes, grand total at just next to the remark, my lord. My lord, make it.
Southern Brahma, yes, 92.75. Yes.
And my lord, here it is 87.75.
Yes.
They have said that it is signed and forwarded by some general manager, but this
Yes.
is not the correct list. And my lord, I can prove it in another way. Is this, my lord? Because here, my lord, may see the at serial number next page at serial number 20, my lord. Daugas Basumatari. It has been shown 73.25.
Yes, 73.25.
Yes, my lord.
Yes.
My lord, may just my lord, may,
Yes.
my lord, this is the I have made a list of
Hmm.
all the marks by referring to the original record. My
Yes.
lord, may here see 153 Daugas Basumatari. This is an Excel sheet from the record. 153, I have highlighted it, my lord. Roll number 153, my lord.
August, yes. We have it in record also. not
Yes, my
all.
lord. My lord may see the
Yes.
marks herein is matching with the one
50
which I have given, but not with the one which they.
52 marks.
Yes, my lord. 52 marks, my lord.
Yes.
But it's not matching with the one which is provided by the petitioner, my. So, my lord, these are the original, and my lord, the mark sheets are also here. And my lord, this one more claim they did is that we have selected respondent number 5 and respondent number 11 having lesser marks. My lord, that is not the case here, my lord. This is the selected list. My lord, the highlighted one are the one who have been selected and in the next page. And all their marks are more than the petitioner's mark.
But this signature which appears in your select list
My lord,
is the same signature where they have this and they have annexed this same signature, same seal.
my lord, I understood my lord would, but for that I've also pulled the original marking where the signatures are there. And this marks tallies with the one which I have produced, my lord. My lord, that is why, my lord, that Excel sheet, the big sheet,
Hmm.
would every of the highlighted are the petitioner's one, my lord. And these are the original marking, my lord.
Why didn't you state this in the affidavit?
My lord, it's there. It's there in my affidavit, my lord.
Which paragraph?
Yes, my lord. It's there in my additional affidavit. In fact, my lord, I have. My lord, para 4, 147, my lord.
147.
146, 147, yes, my lord.
Yes.
My lord, the below list contains the name of the along with the rule numbers. It is pertinent to mention herein the below marking list is the final marked list of selection process of requirement of Sahaya. The respondent hearing claims to produce the original list during the time of hearing. And my lord, I have given a list of 140. In the next page, I have given the entire mark. And I've also have annexed it, my lord, the same one which I have given to you in a, because it is an Excel sheet, might I have to minimize it. That's why it's like this.
Your basic case is that the foundation of their case, that
Yes.
in the merit list,
Yes,
in spite of they securing more marks, that is not correct.
Not correct.
Actually not
na-
correct.
factually not correct even by the mark, my lord. These are handwritten marks of that day. My lord, I have flagged it. My lord may perhaps would like to see it, that it doesn't, it matches with the one which I have given, not the one they have produced. The entire confusion is because, my lord, the rule, my lord, if checks the Excel sheet, there were 60 marks has to be divided among the all the interview as per the rule. So there was an average taken of all the interview marks, and that has been manipulated in the sheet that has been provided by the petitioner.
That is your case,
Yes, my lord.
Mr. Gautam?
My lord, and we
Anything else?
To go to dot because what you believe that it's the original mark. There's a one day when it contains marks are much lesser, your lord. I mean, permitted to go to the record, your lord. So, lord, you can take it up on 13, your lord.
We have seen the records.
you have already
See,
seen the
had it
record.
been something else, these are essentially factual matters, and records have been prepared, has been placed before us.
And my lord, the opposite counsel have also produced the records on 9/11/2023. The last occasion, these records were there on one occasion. That is why, my lord, there's an additional affidavit. My lord may see there's an order of this honorable court. My lord, there's a sign in.
Okay. Okay, we close this then. We'll retain the records,
My
but
lord.
after, at the time of delivery of the judgment, we'll get
My lord.
heard. Should we record your name?
It's a tape record.
Is it there in the court?
He's in court, lord. He was doing a custodial death
Uh,
matter.
This, in continuation of the argument advanced. No, Sri Sharma, Learned Council, Learned Standing Council, APDCL has concluded his arguments and has also placed before this court the relevant records pertaining to the selection in question. Full stop. He has also produced the mark sheets. The list of candidates along with the marks given in original. Full stop. The hearing is concluded and judgment is reserved. The records placed before this court are retained till delivery of the judgment.
My lord.
Lord, if I may, lord, just point out one aspect of it. Page number 120, lord, paragraph 3.
120.
120, lord. So, how to meet certain averments that the marks secured by us, petition number 4 and 8 were higher than the respondents.
Yes.
Document kindly,
Well,
remind lot who are going for record.
My lord, this would all be also required.
No, not required. এইখিনি অলপ ভালকে ৰাখিব লাগিব হা ৰেকৰ্ডছখিনি এইখন কি আছিলে এইখন এইখন লাগিব
My lord, there is a sheet that I have prepared for my lord. That would
Yes.
help my lord to,
This one?
because my lord, their serial number is there.
This one?
Yes, ma'am. That would help.
Have you given the respondent numbers?
Yes, sir. I have at the back.
Okay.
Most of them.
এইখিনি ৰাখি থৈ দিম অতি সোনকালে দি দিম Okay, we'll try to deliver as soon as possible.
Much obliged, ma'am. Papers to put
Yeah.
file work, but
CAV কৰিছে
এইটো original mark.
আপোনাৰ নামটো ৰেকৰ্ড কৰে মই কৈছোঁ এইটোহে বোলে
এইটো original. মই দেখাই দিওঁ আপোনাক আপুনি এটা নাম কোনোবা এটা ওলাই লওক আপোনাৰ যেনে আৰু এইখিনি
মোৰতো মাৰ্ক কৰি উলিয়াই সেইটোৱে আমাৰ লগত টেলি কৰে
কি দেখাইছে এইখিনি অৰিজিনেল মাৰ্ক আৰু আপুনি যোনখন লিষ্ট দিছে সেইখনৰ লগত এইখন আপোনাৰ লগখনৰ নিমিল হেৰি কিছুমান ডকুমেণ্ট পিঠি আছে সেইবিলাকো তাত থাকি যাব আপোনাৰখনৰ লগত কম্পেয়াৰ কৰি
তুমি দেখোন মিলাই দিছে মাৰ্কবিলাক আপোনাকে 7.5 সিহঁতে 9.
এইখনৰ পৰা টেলি কৰিলো এইখনতো মোলে পঠাইছে এইখনত টেলি কৰিলো আপুনি কোনোবা এটা আপোনাৰ কেণ্ডিডেটৰ নাম লওক ইয়াত আপুনি পাই জগছত বসুমতাৰী নেকি
নাই নাই এইটো 8
মোক ৰোল নম্বৰটো লাগিব
ৰোল নম্বৰ আছে তো CAD গৈছে ন তাৰপিছত ৰোল নম্বৰ হৈছে 130
131
আল্ট্ৰাছাউণ্ড
মুছা
হ'ব
আপোনাৰ DGM এ
লৈ যাব নেকি
51 দিছে আউট অফ 60 লিখি লওক 51 আউট অফ April to 51 August to এই গ্র্যান্ড টোটাল আপনার পাইছে সেকশন নাম্বার 4 এ 54.5 এইখন মার্ক অরিজিনাল মার্ক আমরা দেখায় আগ্রামা মুসাহাট 25 51 আউট অফ 60 এটা 25 আউট অফ 60 ইন্টারভিউ হ্যাঁ Agrama Musahari, 23 out of interview. Grand total era divide করলে পাই যাব grand total sheet খন মই পুটত দিলো এইটো আৰু এটা Agrama Musahari 31 হেৰি কৰা না 31 plus
ফাইলটো আছে নেকি
31 51
কপি দিছে আমাকে
No, এইটো মোৰ আমাৰ 25
এটা ফটো ফাইলটো দিয়ক না এবাৰ ফটো ফাইলটো দিয়ক না এটা চিভি কৰিলে এই কাগজ এখন চাব তাতে কাগজ এখন পৰ্টেললৈ কৰি দেখায় হ'ব এই দাদা ফাইলটো দিয়ক তানো আছো ৰ'ব মই কৰি কথা
মই আকৌ ভালকে দেখাই দা DGM
আহি আছে
Agrama Musahari 51 চাই লওক 51 হা এইটো মই লিখিছো
মানে কোনখন কাগজ কৈছিলে দাদা আপুনি দিয়া বুলি দাদা এই যে কাগজ এখন দিছিলে কোনখন
দিলো
কাগজখন দেখাব
Agrama Musahari 25 হা Agrama Musahari 23 ইন্ডিভিজুয়াল মার্ক দিছে ঠিক আছে Agrama Musahari 31 so 31 plus 51 plus 25 plus 23 130 এটা 130 divided by 4 করো 4 Agrama Musahari STP Agrama Musahari physical test no তাইলো দাদা হাইলাইটারটা দিও না physical test no ঠিক আছে DMA দিছে 25 51 31 23 average is 32.5 হয়নে তাৰপিছত তাৰ total mark 600 marks obtained 21 এইটো চাওক 54.5 average দাদা grand total এইটো চাওক আপোনাৰ এইটো চাওক 0.5 তাৰপিছত total marks তাৰপিছত 54.5 academic total 15 54 আপনি plus 15 কৰক না 32.5 plus 15 কৰক কিমান হ'ব 54 নহয় 32.5 plus 15 কৰক না 32.5 এইখিনি এভাৰেজ এ ওলাই দিয়ে সেইটো মই ফিজিকেল ফিজিকেল টেষ্টটো বেলেগকে হ'ব ন হয়নে 9 প্লাছ আগ্ৰামাটো কিমান 32.5 interview plus 13 plus 9 plus 54. This is the grand total out of 100. Average. A to the apni sab 6. और एक ही मार्क एक ही नहीं यार ये साइन करा है
আপনার ফটো এখনো কিতাপখনৰ ফাইলটো কি চেম্বাৰত ৰাখিম আপুনি লৈ যাব সেইটো চেম্বাৰত ৰাখা
এইটো কোটে দিছিল নেকি
এই হেৰি
এইটো ফটো লাগিব দেখালো
দি দিও
নাই
Very good, only I.
But